Page 1 adjournment.
Yeah,
Page number 1, serial number 1 to 4. Page number 2, serial number 5 to 10.
serial number 5 does not survive for consideration. Suit can dispose.
The memo is filed stating that the suit itself was disposed of on 25/9/2023 and no cause survives accordingly. Dismissed as infractions. Yes.
Page number 3, serial number 11 to 14. Serial number 12.
Serial for appellant. And tomorrow, madam.
Why? So furnishing of process. What person inconvenience? Next. Please wait.
Page number 4, serial number 15 to 19.
Serial number 16, Lordship, I am permitted to withdraw this petition.
C.
Yes.
Against the rejection of 125 proceeding, Lordship, for non-prosecution.
What is this liberty?
Lordship, in fact, Lordship, I need to file writ petition because it's dismissed for non-prosecution, Lordship. I file RPFC, Lordship.
So for that I need to look at the paper. Please wait till the matter reaches. Yes, next.
Page number 5, serial number 20 to 25.
Serial number 17, madam.
Yes.
Tomorrow, madam.
17.
Why?
Some personal concern.
On the matters.
No, only one matter.
Give the number so that
Only one matter. 17.
appear for the
Petitioner.
at the request of the counsel the petitioner. List this matter on 13th. Yes, next.
Madam, serial number 18.
18.
I am the petitioner. There is an office objection with regard to maintainability of the revision.
That you have to wait. When the matter is called, you can submit.
Page number 5, serial number 20 to 25. Page number 6, serial number 26 to 30. Page number 7, serial number 31 to 32.
Serial number 32, madam. There is another connected matter.
Post along with that on 12th.
Please. LCR medical.
We'll see. We'll see. If required, then we'll see.
Page number 8, serial number 33 to 37.
So that serial number 36, my lord, going to withdraw the petition. Array is posted for judgment. The petition is not survived for consideration.
A memo is filed stating that the main RA itself is posted for judgment. Hence, the same may be dismissed as not pressed accordingly. Petition is dismissed as not pressed. Yes.
Page number 9, serial number 38 to 45.
Serial number 41. Memo is filed. The petition hasn't become infirm.
You already filed.
Yes, already it is filed by the respondents.
Why the main? Why
Mutual consent divorce has taken place between the parties.
it is submit? A memo is filed.
Along with the judgment and decree of the.
Memo is filed stating that the parties are residing together.
Yes.
Parties are residing together, or is
No, the mutual consent decree of divorce is
They
not.
obtained divorce for mutual consent. As such, nothing survives for consideration. Then this order has to be set aside.
But the condition in that compromise is to withdraw all the petitions.
Correct. But what will happen to the order?
In Worship, I will take it up when the matter is called up.
Yes.
Please.
Because unless that order has to be set
Please,
aside.
please.
Yes.
Page number 10, serial number 46 to 52.
My lord, serial number 52, my lord. For the petitioner, my lord, may I see from Monday, my lord, the inconvenience today.
Inform the other side.
I will inform my lord.
No, please inform and then advise. Yes. Wait.
Page number 11, serial number 53 to 56. Page number 12, serial number 57 to 62.
57. Serial number 57. Next week, man. File for record, sir. I will inform other side. Already informed.
Is at the request of the petitioner, finally on 19th of November.
Please.
No further time will be granted.
Serial number 59, my lordship. I for creditor album to Akri, my lordship. My senior colleague undergone surgery, my lordship. Have it done after next week, my lordship.
When do you want?
After 2 weeks, my lordship.
Go for the respondent.
KBA, my lordship.
It is submitted that the counsel for respondent is not feeling well. List this matter on 26th of November. Inform the other side.
Yes, my lordship.
No objection.
27 or 28, my lordship.
27. Yes. List this matter on 27.
47. Page number 30, serial number 63 to 71.
Serial number 65.
Yes.
2 weeks short of motion. Senior LS, representing on behalf of LS. 2 weeks short of motion. The senior is not keeping that.
Okay. It is submitted that the by counsel the petitioner is unwell. List this matter on 19th November.
Much ado.
Page number 4, serial number 72 to 84. Page number 50, serial number 85 to 92. Serial number 92.
Yes. Huh? He wants it on 15th. What is he saying? 15th of this month. Have you informed the other side? Which one?
92.
Please, why are you asking for time? Huh? No, it's a part-heard matter. It is a part-heard matter. This is for the respondent. At the request of one counsel for the respondent. This is matter on 14th. No further adjournments.
Page number 60, serial number 93 to 97.
Why? Huh? All 2021 CRs and all. Nobody is coming forward to do the matters. If senior is not there, you should get ready and argue. Finally, on 19th, no further adjournments.
Serial number 96.
Yes.
Serial number 96. You have to respond. 2 weeks time. Marriage is
There should be a reason for 2 weeks.
Marriage is there.
Marriage is there. Same on this is matter on 26th. The request of one counsel for the respondent. Yes.
Page number 7, serial number 98 to 100.
99 minor. And for the petitioner minor. In the impugn judgment, there is some evidence portion is there in Kannada language.
Not, I'll understand. Don't worry, I'll understand that.
Some of the portion in
See, there is a part of the order. Some extraction is in Kannada. No problem. You can read it. I'll understand. Yes, next.
Yes. Your Lordship, I am requesting to permit me to make my posting memo submission of my review petition on order, MSA order. It was in Bengaluru bench actually. I finished the compilation everything. I just waited for office to posting the case actually. But they are asking me to get the vote from me.
Bangalore matter, you'll give here for posting. What is that?
My review petition posting.
MFA of Bangalore bench should be there. Nothing to do with it. Yes, next.
List number 1. Very good. Serial number 1. Bangladesh Custody, CPP, in Dharwad.
We are filing a fresh application of compromise.
Where is that? TD is given to her?
No, now they are.
We have given. Now you.
The present criminal petition is filed. The present criminal petition is filed to quash the proceedings in criminal case number 545/2021, pending on file of the second additional civil judge and JMFC, Dharwad. The offences are under section 498A, 323, 504, 506, that with 149 IPC, and section 3 and 4 of the Dowry Prohibition Act. A memo is filed before this court. The compromise memo is filed for compounding of the offences as per the terms of the compromise. All the bold or articles pertaining to the wife were returned to her, and an amount of rupees 4 lakhs is paid by way of a DD number 183104 dated 6/11/2024 as a full and final settlement, and she'll not claim any maintenance in future, and also she'll not claim any compensation, right, title or share or the property of the husband and her family members, or from the respondent number 1 in future. And they also agree to dissolve their marriage by way of a mutual consent, which is pending before the Family Court Dharwad in MC number 315 of 2024. And they want to, and the wife wants to withdraw the RPFC number 100192 of 2022. All the parties are present before the court, and the wife who is present before this court submits that R2, wife public R2 submits that that she has, as per the compromise memo, she has received the articles, the gold articles and other utensils, and also she received the DD, and the DD of 4 lakhs is given to handed over to her before this court, considering the settlement arrived on between the parties, and in the light of the compromise petition filed before this court. Before this court, the criminal petition is allowed, and by quashing the
Sorry to interrupt. On submission. Vice versa, respond number 2 also returns.
also.
Return the.
No. What we'll do is that then this will be formed part of the order.
Please.
So not necessarily that everything is. No, her interest has to be looked at.
Please.
Accordingly, the criminal case number 545 of 2021, pending before the second additional judge in JMFC, Court Dharwad, for the offences under section 498, 323, 504, 506 read with 149 IPC and 3 and 4 of the Dairy Prohibition Act is quashed. Also, then we'll pass a separate order for RPS.
Please, please.
Is quashed, and the memorandum, the compromise memo that is filed before the court shall be annexed to the order in the light of accordingly quashed in the light of the compromise memo, and the compromise memo shall be annexed to the order. Next, RPFC. Give the RPFC one. There in that only is there. In the light of the compromise memo filed by both the parties, and in criminal petition number 102850 of 2022, the RPFC is filed by who? Filed by the wife. The RPFC is dismissed.
That's not deeply obliged. My turn.
Next.
Disclosure in terms of compromise petition.
Signature.
Signatures.
Please.
Take all the signatures and Aadhaar cards and all. Yes, yes, what is this being spoken to?
Matter members, filed wakalat on 4th members. Without saying my name and what it was disposed on 5th.
Look, that's the order is there. I think. Anything else you want to say?
One thing, my lords, the parents of the respondent are suffering from heart diseases. My lords. The father has gone twice with operations, my lords, and mother is also, he is looking after them, my lords. Hence, only the request is, my lords, in between any place, my lords, Yelburga to Chitradurga, anywhere, my lords, transfer, my lords, center of the place, it could help us both.
There are two children, the distance between Chitradurga to Koppal is 200 kilometers. This being a lady nurse along with children.
This court by order dated 5/11/2024 had disposed of the petition whereby has allowed the petition whereby MC number 64 of 2024 pending on the file of the JMFC Chitradurga is withdrawn and the same is transferred to the Court of Senior Civil Judge Yelburga. Now the petition is today this is placed before this court and the caption for being spoken to. It is submitted by the counsel for the respondent that he has filed wakalat on
4th November.
on 4th on 4th November, and this matter came up before the court, and on 5th on 5/11/2024, and his name is not reflected in the cause title. As such, he was not given an opportunity to advance his arguments. Next one. It is submitted that the
May I mention, I filed a statement of objection to.
also filed statement of objections. Land counsel submits that the parents of the respondent are suffering with health ailments, and he has to take care of them. It is submitted that even for him it's very difficult to appear before the courts at Chitradurga, Yelburga, as the distance is 200 kilometers. Land counsel submits that considering the interest and convenience of both the parties, the case may be transferred to some other place in between Chitradurga and Yelburga, so that it will be convenient for both the parties. Considering the submission of the land counsel for the respondent, and also considering this, the objections filed on his behalf, this court has heard the counsel for the respondent and also perused the objections filed by him. Now, the distance between both the places is 200 kilometers. According to him, he has to take care of his aged parents. And according to the counsel, according to the petitioner wife, she has two children. She has no means to travel, and she has to take care of the children. Transferring the matter to in-between place would not be in the interest of the parties, and considering the inconvenience caused to the wife, and also as she has to take care of the two children, this court has to view that the 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 MC has to be withdrawn and has to be transferred to the courts at Alburga. In view of the same, the order as passed by this court on 5/11/2024, Courts Court. Yes, please.
What's still number 3? Come, start.
Yes,
And for the petitioner, my lord, the main matter is itself disposed.
dispose of. Take that. Land counsel for the petitioner submits that the main matter itself is disposed of on 17/9/2022. Hence, CRP has become infructuous, dismissed as infructuous. Next.
Still number 4, real party.
Yes.
Subjections will be complied in each time.
But it says CRP of 2022. Why the office objections are not complied with till 2024? In on 26/10/2023 itself, 2 weeks time is granted. What are the office objections? They're all simple objections, and for that reason it's pending from 2022. Not to by Tuesday, office objections shall be complied with. This is matter on Wednesday.
Okay.
Yes.
Still number 5. Still number 6. Real number.
Huh?
I appear for the petitioner.
Yes.
Let's matter before the trial court is dismissed for non-prosecution. Let's say they have filed the miscellaneous for restoration of the suit for us. If the suit is restored, the CRP has to be revived. I am filing a memo. At the time being, the CRP may be closed. After the restoration, reverting the reserve in favor of the petitioner to revive the suit.
So first to comply with the office objections, we'll
I
see.
shall.
Why you not, which is 2022, serial number 2 to 4, what are the
The court fee
objections?
is being made good minutes.
Huh?
Court fee is already paid. Correct.
Same, it's also listed on Wednesday, by Tuesday, office objections shall be complied with.
Great.
Or else the appeal shall stand dismissed.
Yes.
Yes, the petition shall stand dismissed. Yes, next.
Still number 7. Dharwad.
No representation for dismissal tomorrow. Next.
Still number 8.
This kind
All this also will come on Tuesday. Wednesday, by Tuesday, office objection shall be complied with. Yes, 9.
Still number 9. Use petty money.
No representation for dismissal tomorrow.
Still number 10.
It is fine, but respond number 2 has court will take care.
When was respondent number 1 died?
For respond.
Postal Shara deceased resident to sender.
When was it?
11/1/2024.
11/1?
11/1/2024.
11/1/2024, respondent died. No steps were taken till now.
Not, sir. After payment of PF lots, the Return has delivered
No,
that.
no, that is delivered on 11/1/2022.
I will take steps now.
Please do it in a week or else we'll dismiss the petition as far as the respondent is concerned. The petitioner shall take appropriate steps to bring the alerts of the deceased R1 and also furnish the process for issuance of notice to R2, R3 and R5 within a week's time, or else the petition shall stand dismissed without further reference to the court. Yes. Yes.
Joshi. Shadi Joshi.
No representation for dismissal tomorrow.
Seal number 2. Foundation Agreement. Foundation Agreement.
Same order.
Seal number 30. Arke Kulkarni.
The petitioner may kindly be permitted to withdraw the petition and be able to file the regular custody arrest. As the imperial order is passed in order 7 rule level by
Is
the
allowed. What is this file? 13/10/2023. It's after 1 year you are seeking the liberty. Then who will answer to this 1 year limitation?
in the meantime the petitioner is reported that he is dead. And
Huh?
it is reported that the petitioner is dead. Now
Then where is the permission now?
I have to get the LRs and others. So I have written the letter, it has been written.
We'll adjourn the matter to first of all bring the LRs on record. Then will the permission and all. Let's this matter after 2 weeks, by the time it is submitted that the petition himself, which petition is no more, steps shall be taken within 2 weeks, or else the petition shall stand dismissed without further reference to the court. Yes.
Seal number 40. Integrity.
2 days time will be granted. 2 days time will be granted. Right, literally.
2 days time is granted for complying for paying the process, or else the petition shall stand dismissed.
Please.
Seal number 15.
Yes.
Please, filing the memo that I am not claiming a relief against the legal rights of the deceased. Small issue.
No. How many are the respondents? Oh, this is RPS.
Yes, CRP. One was the contesting respondents, one was only the respondent number 1.
No, this is RPSC.
CRP.
Which item you are referring to?
50.
Yes, 15. Who appears?
My lords, advocate for the petitioner, my lords.
In the criminal petition, the response herein was the petitioner's there, my lords. We have paid the process fee for the same address, but still the consignment was not found. So notice to response may be held satisfied, my lords.
For second time, pay the process.
Please, ma'am.
Process shall be paid within a week. Same default order. Yes, next.
Seal number 60.
Yes.
Article 60.
Somebody was making a mention in the morning. Passover, let him come. When the matter is called, should be there.
Passover.
Yes.
Seal number 17. Seal number 18.
You got it.
Legally 14%.
My lord, on the petitioner is revision.
Let us just see what is the maintainability issue raised to be clarified. When in the challenging order, there was permission to withdraw the suit. Plaintiff is permitted to withdraw the suit. However, the permission to file a fresh suit on same cause of action is not granted. So also, the MA order dated is also dismissed as not maintainable. What is the order improved? Let us see. Which page?
Mixture. Page number 11 to 16.
Page number
11 to 16.
Operating portion at page 15 and 16. Order. May I read? IA number 3 is filed by appellate plaintiff under order 53, rule 1 sub-rule 3. OCPC is hereby allowed in part.
No. Are you reading the order at page 11?
Page 15. Order.
No, read from page 11.
Page 11. Right. Order. Contentions of update are as follows. Applicant has called to an update and submitted that the suit land was acquired by state government by notification on behalf of state. So and land record survey office Dharwad are the necessary parties to the suit. In their absence, no proper agreement can be made. The defendant number 2 and 3 are to be omitted. The police commissioner of office Navanagar has given consent for operation of abnormally without a self-petrol station along HTBRC highway is in violation of prescribed norms. The petrol station neighbors consent documents whose existence was unknown to the applicant necessitated reshaping the claim and has great effect on suit. The cause of action and nature of original suit on the issue of encroachment, setback, health and safety remains same, and by allowing this application, no prejudice will be caused to defendant and to avoid multiplicity of proceedings by filing another suit for such relief, hence late to allow this application. On the other hand, defendant 1 has filed objection to this IA and contends that application is false, illegal and void of notice. It is not maintainable neither in law or in facts. The facts and circumstances of the case are behind the scope and the ambit of order 20 rule 1 sub-rule 2. Here the sub-rule is wrongly mentioned. It is sub-rule 3. It cannot be invoked under present case. The allegations made in the application and affidavit are not admitted by this opponent. No sufficient evidence are assigned to the opponent has completed the construction and given obligation for fuel station after duly obtaining all requisite permission as per law. The applicant, in order to cause harassment, has filed this application. The opponent has obtained the approval of the petroleum so and commerce and has also obtained agency from police commissioner. He has applied all the conditions imposed by the department which provides the adequate safeguards. It is admitted that the defendant owes money and invested crores of money and constructed a close from their house. Lawfully owned property. Applicant cannot be permitted to file a fresh suit on the same cause of action. He has no right to that. Third counsel for the applicant and opponent meticulously tells the following points are as considered. Whether the instant IA deserves to be allowed. What are my reasons? Point number 1 on point number 1, the applicant has filed instant suit seeking receipt of mandatory petition against the opponent. It has
Do you want to withdraw the petition?
Because subsequently, the land was acquired by the PRTs. And for that reason, I have to add, because that...
Can't you add in the very same suit?
Pardon?
Can't you add in the very same suit?
It could have been, but I wanted to withdraw. And there is
Giving liberty is the discretion of the court. When something can be done in the very same suit, just like that, you can't, if you want to withdraw. Giving liberty is the discretion of the court. Now, court feels that when you can implead the party in the very same suit, on the very same cause of action, why should there be a fresh suit?
Yeah, because there was a misjoinder also. There was one party.
Then join it.
But there is under sub-rule 3, if there is any misjoinder, that can be by withdrawing the suit and filing a fresh suit.
No, you can't implead. You can't implead in this suit the other respondents.
The respondent I can implead.
Because it is a subsequent cause of action. After you have filed the suit, something else has happened. So no, you can implead them in the very same suit.
But the trial court would not have dismissed the order, dismissed my application. Along dismissal, they have dismissed the entire suit. The trial court would have ordered me to make an amendment. Not
IA number 3 filed by the applicant plaintiff under order 23, so is hereby allowed in part.
Plaintiff is permitted to withdraw the suit, however, the permission to file a fresh suit on the same cause of action is not granted. This is not allowed as per law under sub-rule 3. Sub-rule 1, absolute withdrawal is there. Sub-rule 3 is a conditional withdrawal.
Office objections with regard to the maintainability or over issue notice to the respondents. Yes, ma'am.
Issue notice. Issue number 19.
I am not claiming any relief against the
The LRs of the respondent number 2 hearing.
How many are the respondents?
5 respondents. 1 to 5 1 are contesting. Only the respondent number 2. He is a village accountant. He is no way concerned to the suit.
What is the suit for?
My lords, the suit is for the declarations. Holding that, my lords, may I pass on the genealogy?
No, respondent number 1 and 2 here are the plaintiffs.
Yes. No. The respondent number 1 is a plaintiff.
Hmm.
He filed a suit claiming that, my lords, the present respondents hearing are not the legal heirs of so and so person, which is the negative in relief as such. So that is for the relief, the genealogy, which has also.
No, we'll go to that later.
Yes.
No, again, you are not seeking any. No, he is the plaintiff in the suit. He is no more. First respondent is the plaintiff.
Yes.
He is no more
He
now.
is here now.
Huh?
Yes, he is alive.
R2 is no more.
R2. Oh,
R2.
they are the legal heirs of R.
No, he was no way concerned to this. He is no way concerned to the party, to the suit as such. He is a village accountant, wrongly made as a party before the client court.
That is not only he is involved. We have allegations that the documents are manipulated, and the defendant number 1 to 5 have been entered that name in the revenue report. With
So,
that,
1 minute before you both of you go.
yes,
This, as per this, I'm looking at the cost item
Yes,
in the CR.
yes,
In that, first respondent, Srikanth,
yes,
is the plaintiff.
yes,
With whom he is representing.
and for the,
Second is no more.
he is no more.
And you are not seeking any relief
Yes,
against
I'm
him.
not.
Let him not.
Yes.
If you know that's his problem.
Yes.
If something is, they will say that
that
notice
will
to
be-
them is dispensed with at the risk of.
In the memo I have written it is my risk.
Yes. Give that memo.
Yes.
The respondent number 2 in this revision is no more. The counsel for the petitioner has filed a memo stating that the petition is not claiming any relief against LRs of the respondent number 1. Hence, notice to the respondents may be dismissed with at the risk of the petitioner. Accordingly, the memo is taken on record and notice to the respondent number LRs of respondent number 2 dispensed with at the risk of appellant. Yes.
For a moment, for translation, the genealogy.
Take that.
Yes.
What is I number 3?
Yes, my lord, I filed an application for the rejection of the plaint.
No. As per
Same, my lord.
the cause list, what is I number 3 in this case?
That is only the legal aids applications.
Non-compliance of office objections based on IA number 2. That is LR.
Yes, I have.
That is over.
Yes.
That is over. Then in IA number 1 is for stay.
Yes.
IA number compliance of office objections based on IA number 3.
Delay for legal aids applications.
In view of the same, IA number 1 and 2, there are nothing to be considered with. Accordingly, both IA number 1 and 3 are closed. Yes, please.
Yes.
What is this revision?
But the suit is for the relief of the declarations.
So, what is the impugned order?
The impugned order was not the rejection of the plaint filed by the defendant's hearing has been dismissed. Before going to the impugned order,
No. Before going to the impugned order, we'll go to your application.
actually, for the moment that is page 34.
Yes.
For the reason in the accompanying affidavit, defendant.
Come to the affidavit.
Yes, yes. The relevant para, my lords, 6. 4, it starts from the 4th. It brings the kind notice of this honorable court on perusal of the plaint. It clearly barred by the limitations and the present application does not have a locus standi, not a locus standi. The relief when the nature of the declaration is completely in the negative relief. When the court is not entitled to give a negative relief, it is the plaintiff clearly barred by the limitation on looking into the entire nature of the facts and circumstances in the genealogy submitted by the plaintiff.
What is the relationship between the plaintiff and the defendants and the person to whom he is referring to as that they are not, take that.
Yes, for that moment. I already passed.
You already passed? Yes.
Sorry.
Yes.
The relief claim, my lords will get maybe in a dark, Srikanta, at the bottom, my lords.
Srikanta.
He is a plaintiff. He filed, my lord, the suit claiming that Padmavati, Channappa, Sharnappa, and Sunita and Balappa are not the legal heirs of Balappa.
Are not the legal heirs of?
Balappa, at the left side, my lords. Balappa.
That's the first column.
Yes, sir. First column. Balappa, my
No. Balappa's son, daughter is Gauramma.
Gaurav, wife, my lord.
Wife is Gauramma. Gauramma is the wife. And
Yes.
they have a
Gavisitappa.
Son.
And
That son-
Padmavati, wife.
that son has
Son, my lord. Wife.
Padmappa is the wife of Siddhappa.
Gavisitappa.
And their children are 1, 2, 3, 4.
Yes, Lord.
And
Chandrasappa.
who is this person?
This person, my
Srikanta?
lord, he is the son of the one, kindly take, my lord, the on the right side.
Mm.
Gavisitappa dead. Where, my lord, he comes? Channappa, Premava, Shivappa. He is the son of Premava.
No. What is, now we have to look at
Yes.
this Basappa.
Yes.
Basappa's children are all this Balappa, Fakirappa, so and
Yes.
so.
Yes.
So this family is like, he is also from the Basappa's family. That is Basappa's grandchildren.
Grandchildren.
Mm.
Grandchildren. So, Srikanta was born much later than the Balappa when he was died prior to independence. So, Balappa has no, Srikanta has no locus standi, my lords, under the, we are saying that, my lords, Padmavati, Channappa, Sharnappa are not the legal heirs of Balappa. He cannot claim relief as such, my lords, as it is clearly barred under section 34
Let's
of.
please now let's again look at your application.
Yes. Page 34. The relevant para, my lords, page para number 4. Where I read para number 4 also. How you, my lords? The property bearing OS 145 so and so is a sale consideration 2 lakhs in the present sale totally 6 properties stated in the para of the sale. Now looking into the entire valuation of the property, that para 6 is the relevant. The plaintiff in the above said suit is suppress the material facts which is necessary to bring the kind notice of the honorable court. On perusal of the genealogy and also the branch of Devshitappa and sons and the daughters of Devshitappa had filed an impleading application before the Honorable Supreme Court 5426 for 2002, and the SLP thereupon contending that they are sons of Devshitappa. And when the matter is, when this being the fight, the Supreme Court, when the being contended that they are the members of the joint family in the present case, it is surprisingly come to the notice that before the Honorable Supreme Court that the said application is not been allowed till today, and the Supreme Court has clearly passed an order on the present including applications will be heard along with the minutes, and the said order is on passed on 15/2/2016. So on looking,
I have seen that. Please come to the plaint.
please. Impute order, my lord.
Plaint.
Plaint, yes. Plaint, my lord, so the relief, page 21. First relief, my lords, seeking the negative
Plaint is
declaration.
in Kannada.
Yes, my lords, first relief is insofar as the negative relief is concerned. Declare that, my lords, they are not the legal heirs of the Balappa. And second relief is challenging the seal deed, which has been executed by the defendant 1 to 4 in favor of the defendant number 5. Long back in the year 2013. So, my lords, the Honorable Trial Court in the impugned order says that these all contentions could have been taken in the written statement, not in the rejection of the plaint assets. So, my respectful submission is this. So, the scope of Order 7 Rule 11 and the written in the written statements are entirely different. The court want to look only the plaint amendments.
But the court is looking at your the objections now.
Good, but for a moment that
No, for understanding so many things,
yes.
court has to look at your Order 7 rule on petition, not at the plaint. Does the plaint disclose all this?
No, it's not discloses. Only on the two ground, on the ground of the purely the question of law. On the delay,
and my lords, the locus standi, and my lords, on the relief claim, as the relief is entitled under the Specific Relief Act under section 30.
Let's see the finding on that.
Yes. Page 58. And before that, my lords, he has already filed another suit for the relief of parties and property. He himself has filed a suit where all these parties and all the
But
property.
anyhow, we cannot look into all that.
Yes.
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 Let's see.
Before proceeding, my lords, para 25 minutes.
Yes.
Before proceedings, further it is to be noted that the defendant number 1 to 5.
No. Para 24.
24. Yes. This court has carefully gone through the records and it is reveals that defendant herein, IA number 3, seeking the rejection of the claim on the ground that suit is undervalued and suit is barred by limitations and the plaintiff is claiming the negative relief, hence the suit is not maintainable against the defendants. Before proceedings further, it is noted that defendant number 1 to 5 is nowhere stated in the written statement that the written statement is not yet been filed. Written statement that it is undervalued, the suit is barred by limitation, and the plaintiff is claiming the negative relief, hence the suit is not maintainable against the defendant. Further, they have not set up the defense in the written statement. For this time, the defendant is set up those defenses. Hence, it can be said that the defendants have suppressed the facts mentioned in the accompanying affidavit IA number 3. What prevented the defendants to plead in the written statement? In this regard, the defendant number 1 to 5 are silent. When the matter is posted for cross-examinations of PW1, they have come up with IA number 3 seeking the rejection of the plaint. Further, the defendant will have an opportunity to cross-examine the plaintiff with all the materials pointed out, including the grounds urged in the IA number 3. Further, the defendants have not amended their written statement by mentioning the defendants set up the IA number 3. They had extracted, my lords, all the provisions. And the last para, my lords, court said, my lords, the para 37. Rest of the things they have extracted the provisions of the law. Yes, 34. For filing of the plaintiff need to have been a local standard. If he, she or she shows some legal rights or the persons has been violated, such a violation should also result in some injuries caused to a person. If no legal rights has been violated, the person will not have a local standard of filing a suit. It is basically the ability of a party to show the court that there was a sufficient action behind the filing of the suit under Order 7 Rule 11. When the defendants upon their any ground violated the resulted in the rejection of the claim, where the order of the Supreme Court. At this stage, the applicable relief of the decisions in 2004 SAR, so here the court has held that the question of limitations could be decided by only the pleading benevolent. Further, it is profitable to the judgment referred by the Honorable Court that same reported in so and so and so, wherein the High Court of Karnataka held that for rejection of the plaint, the evidence of the plaint alone to be considered. The court
yes,
has
what do you say about on that section 34 of the Specific Relief Act?
My lord, first of all, that genealogy I will not accept this.
Not genealogy, only on the negative relief that you are saying.
Negative relief, madam, that there is a true relief in this claim. We can, the petitioner may be sought for that they are responsible. The defendant 1 to 4 is not.
You have not said that let there be a declaration that you are the owner. I mean, you are the legal heads of so and so.
I am the legal heirs. I have pleaded in this claim.
Not in the plain relief, I am saying. It's not your relief that you are declare that you are the legal heads and they are not the legal heads or something. It's only in a the relief has framed by you. How is it not by section 34?
The matter is pending before my trial court, and
it's a question of fact. It's a pure question of law because you don't have to look at any other thing. What is the prayer that you are sought for? Is it not? Is the court not supposed to look into that?
No, they want to collude with the owner. They want to sell the property belongs to my ancestors, and for that purpose,
you may have whatever but there is a procedure for framing a prayer. What is the answer of the court on section 34? For section 34, you don't require a full-fledged trial. What is your answer to that? That's the only thing to be decided in this. Huh?
Submit next week.
No, you please look into it, and on the face of it, as of now, subject to what you say, the court feels that the trial court had wrongly answered that issue. Look at it when you want.
Next Wednesday.
Huh?
Wednesday.
Wednesday.
Posted for first examination on 11th.
On?
11th.
On 11th, that's Monday. List this matter on Wednesday. Till such time, there shall be stay of all further proceedings in so and so.
On 14th.
14th.
Yeah, absolutely.
Till such time, there shall be stay of all further proceedings.
Please.
Before granting the order, learned counsel for the petitioner submits that when the plaintiff had filed the suit seeking the negative relief, the same as part section 74 of the section 34 of the specifically defined, that aspect is not considered by the court. Learned counsel for the respondent submits that he'll submit his documents on the next week. Submit his documents, and the matter may be adjourned to next week. It is submitted with the learned counsel for the petitioner defendant that the matter is coming up on 11th of November. In view of the same, there shall be stay of all further proceedings on the file of so and so till the next date of hearing. List this matter on 14th.
Okay.
Only that issue, nothing else.
Section 34.
Huh?
Section 34.
Section 34.
Article 57 of the Limitation Act.
That all limitation and all is a question of fact and law that will be taken care of by the court.
Yes.
Only on this issue, on other issues, court's findings are correct.
Yes.
Yes, next.
Seal number 20. Nayana Kumar.
Yes.
I have to receive instruction from my client about the whereabouts of the respondent. Once we get to know the new address where he is residing, I will issue notice. Matter may be
7 days absent, hence written. Who filed the MC? Who filed the MC?
the respondent has filed a request of convenience petition in Vijaypura. We have sought for
Then take out notice on the counsel appearing for the respondent before the trial court.
Will do.
Petition is permitted to take out notice on the counsel appearing for the respondent before the trial court and shall file a memo to the effect by 20th November.
Seal number 21.
And summons. And summons. Yes, 21.
21. PH5D.
No representation for dismissal tomorrow.
Seal number 22. Contestation Sirena.
Same order.
Seal number 23. A. Shetty.
My lord, respondent, my lord. Postal sir is stating that no.
No, who has filed the MC? Husband has filed.
Yes, my lord.
Then take out notice, same order. Take out the hand summons on the counsel appearing for the respondent for the trial court and shall file a memo to the effect by 20th. Yes, next.
Seal number 24. There shall consider the wife.
Same order.
Thanks.
Hand summons on the
Please.
counsel appearing for the respondent
Please.
and a memo to that effect by 20th.
Please.
Yes.
Number 22.
Huh? No. 20th. No, by 20th then you should list it. By 20, if it is 20th, then it shall be listed on 21st. All the matters. Yes.
Number 25. We are part.
It will this is non-prosecution. 125 I'm not proceeding.
So how can we RPFC with maintainable?
Writ petition.
The present application is filed, agreed with the orders passed by the court, where the application is dismissed for non-prosecution.
Yes.
Dismissed for non-prosecution. The office has raised an objection with regard to maintainability. Office objections with regard to maintainability are sustained, and the RPFC is dismissed as not maintainable. And the office shall return the papers to the council with the liberty to file a appropriate petition. Yes.
Seal number 26.
But the TF is paid not on the same address where the petition is received from her.
Take out notice on the
I
council.
do.
Same hand summons, 20th, listed on 22nd. Yes.
Interim order maybe it's.
Interim order, just look at it, if it is there, extend it in the next date of hearing.
Please.
Yes, 27.
Okay, sir. Sundaram, your part.
Hello, I'm sitting 1 week time.
Huh?
I'm sitting 1 week time.
See, take out hand summons on the council appearing for respondent and file a memo by 20th, it will come up on 22nd. Yes.
Please try to extend this.
Huh? All interim order will be extended wherever it is there. Yes.
Number 28.
Correct address will not.
Take out hand summons.
Please do not.
20th, 23rd, it will come up on 22nd.
Please.
File a memo by 20th.
Please.
Yes.
This is interim order.
All it will be extended.
Please.
Yes, next.
Number 29.
Where is the memo?
No.
The petition is filed. The memo is filed seeking to withdraw this petition as the MC is filed. The petition is seeking transfer of MC number 6 of 2024 from Sindhanu to the Davangere. The jurisdiction lies with the principal bench. Hence, the petition seeks permission to withdraw the petition with the liberty to file a appropriate petition before the appropriate bench. Accordingly, dismiss with the liberty to file a fresh petition before the appropriate court. Yes. Next.
Hearing on 9. Number 30. Cross denied.
Delay of 87 days to kindly be conducted.
Uh-huh.
A delay of 87 days. Kindly be
Notice
conducted.
has to go. Notice to the respondents. Receives our petition notice to the respondent. Yes, next.
Number 31.
We just see what is the CRP first.
But CRP with regards to amount, the KRDCL has not acquired the land for widening the road. Wherein the amount has been deposited before the district court. Wherein it was the trial court has not refused, not allowed to deposit the amount. Now, for that here they have to come CRP. There is in one case there is a death of the person, death of the respondent. In another there is a delay of 3 days. Only in respect that their contention is that no notice is served before passing the hour.
2023 CRP by the Special Land Acquisition Officer. What will happen to the amount? What will happen to the people whose land is acquired?
In fact, send some of the response signing the LRs, send the arrears also to the KRDCL.
Where is this order you are referring to in writ petition number 100799?
Please.
In your synopsis, you relied on an order passed in writ
Yes,
petition.
madam. I
Where is that order?
have produced along with the petition. Here page number 16, one annex D. Here the only the general award will pass and the amount has to be deposited. Your Lordship kindly take page number 24. That is page number 22. That operative course of the amount here, the guidelines have been issued by this honorable court, wherein the response are at liberty to get the deposited amount released in their favor by reserving their right to challenge the correctness of the award.
Where is the impute order?
Impute order, page number 14, madam. Page number 14. And that is the General Counsel has submitted that the petitioner review officer has passed an award which is deposited in the court referring to this case. The counter to it, the General Counsel for the respondent submitted that Suren Chand Babu has not participated in the acquisition proceedings for the reason he has not served with the award notice. In spite of which, the amount of rupees so and so is deposited towards the amount. When there is no participation of the respondent, the question of deposit of award amount does not arise, as petitioner penal counsel has not produced any document to show that the participation of the respondent on service of notice. In view of those submissions, prima facie the deposit of award amount is so and so. But here, what happened, my lord? Their contention is that, my lord, the award notice has not been served. Unless and until award notice is served, the court can't take the deposit of the award amount. Therefore, it has been dismissed. In the identical question, wherein I have produced the order copy of past in writ petition, in that manner, the court, this honorable court has observed that let the amount.
Like you appear for the respondent. Now, these are two things. No, they want to deposit the amount. Now, if you say that no notice is given to you, or you have never participated in the award inquiry, your remedy is something that somewhere else. What is the difficulty of the court? Someone has to be deposited so that it will fetch interest.
Their contention is only this minute. If the amount has been withdrawn, then they will lose the money.
Right. You are only depositing the amount.
Only depositing.
If it's for you to withdraw it or not to withdraw it, and you have to question it, saying that like we are not participated, no notice is given to us, and also the difficulty of the court. That's altogether different proceedings, sir. How will the court decide whether the notice is issued or not? It's only depositing of the amount before the court. Now they will deposit. For it, no, on when it comes to the light that no notice is served to you, or if otherwise it is said that if the amount is lying with them, instead of it, if it is in the court, they'll deposit in the bank and some interest will be fetched.
Yes, my humble submission is only this, sir. Let they
whatever your claims are, whatever your claims are.
Liberty to challenge there.
Liberty. And only you're not doing it till now. No, this limitation. This is not operate as a it will not come. It's not of you can't claim this for the purpose of limitation, because yours is an independent cause of action. Whether they deposit, not deposit, or the court dismissed it, not dismissed it. You should have questioned it by this time.
Liberty to challenge the award lawsuit.
That we cannot say like whatever you want to do, you do. It will not come in your way. If you are ignored by any of the actions, it's for the land user to do. Now the position has been taken.
Position has been taken.
Then why are you keeping quiet? When was the position taken?
But the court has been rejected. Even only saying that unless and until notice has been served on them, the court cannot accept.
No. Let's not go to the
only court has observed. Therefore, the question of limitation in this case, the question of limitation as per the new act is only 120 days. Therefore, reserving liberty, then once the court has been reserved the liberty, then they can approach. Even the service of notice. If the award notice is not served, the question of limitation will not run.
Award is passed long back. So how will the court give them liberty now?
But no award notice served. If there is a award notice is not served, then the question of limitation is not served.
For that, how will this court has not decided all that whether notice is served or not. Maybe it's for them to go before the appropriate court and say, because I have not received the award notice, so limitation will not it has not at all started.
Yes.
So it won't apply.
Please.
But for that this court cannot say, will not give any liberty. Court can say that what I'll say is the court shall, like whatever amount they want to deposit, let the court permit them to deposit it. If the petitioners and respondents have any grounds, if it is permissible under the act, under the law, in accordance with law, you can file your application. Now, first, where is IA? IA 1 of 2023 is filed to connote the delay of 403 days in filing the revision. What did you say? What are the reasons for the delay?
It may be condemned.
Huh?
It may be condemned.
No. It is stated that the order was passed on 24/9. This should be a docket order, separate order. This in I number 1. That the order was passed on 24/9/2021 and they applied the certified copy of the order on 3/2/2023, wherein the copy was furnished on 7/2/2023. Since the petitioner, being the special land acquisition officer, could not take the decision in order to file petition for challenging the dismissal order. However, immediately on dismissing the application, the petitioner addressed the issue with regard to filing of the petition before the High Court with the concerned authority, and thereafter the petitioner made correspondence with the concerned officials with regard to the same, and a decision was taken. After taking the opinion, it is also stated that as per 77(2) of the RFCTLARR Act, it is mandatory to deposit. Just say as per the provisions of the 77(2) of the Land Acquisition Act. It is mandatory to deposit the awarded amount before the authority, to which a reference under section 64 would be 64 would like. If they are not permitted to deposit the amount, it would cause, and the delay in filing the application is not condoned. The petition is not condoned. There would be the petition would be put to irreparable loss and hardship. No objections are filed by the respondent concerning the reasons stated in the accompanying affidavit, and as it requires for filing an appeal, as it requires the approval of the superiors of the petitioner. Considering all this, the delay of so and so is condoned. Next, main order. The present revision is filed, agreed by the orders passed by the. Where is the improved order? Page number?
Page number 14.
Agreed with the order dated 24/9/2021, where the court has refused to receive the amount, refused for the deposit of the award amount. The facts of the case are: the petitioner for establishment of Ginigere Gangavati Sindhanur within brackets Karnataka Highway number 2 and its widening and improvement under within brackets PPP build, operate and transfer BGF scheme. They wanted to acquire the lands in Marali village, Gangavati Taluk and Koppal district, and a land notification was issued under section 15 of the KH Act, and after conducting joint survey, final notification was issued under section 19 of the KH Act, and the general award was passed on 19/10/2016, and the award notice was issued under section 37(2) of the Act to each landowners, including the respondents herein. Since the respondents are avoiding the service of notice by the postal authority, the petitioners, having no other remedy, approached the district and session judge at Koppal in LAC number 4 of 18 within bracket 15 of 2017 under section 64/1 of the Act, seeking deposit of the compensation amount, enabling the owner or interested who has not accepted the award to receive the compensation amount. The learned judge, by order, reviewed had has refused to receive the amount on the ground that the deposit of amount is bad under law. It is submitted that in a identical situation, when the court had refused to receive the amount, we were refused for the deposit of the amount. No, when the reference court has permitted the LAO for depositing the amount, when the landowners filed a petition before this court, when this court permitted the land acquisition officer for depositing the amount with the direction to release the amount to the landowners and also direct the LAO to pass general award in the event the owner of the land has not consented for the award passed for the land acquisition officer. They can avail the remedies available to them. The counsel appearing for the petitioner submits that the court has failed to exercise the jurisdiction vested in it. Next part. The counsel appearing for the respondent submits that no notice is served on them. The award notice is not served on them, and that they have never participated in the inquiry, and the court had rightly rejected rightly held that the amounts cannot be deposited before the court. Next part. Having heard the counsels on this side, there is the material on record. If the petitioner has not received the award notice when the land acquisition officer had failed to follow the procedure as contemplated under the Act, if there is any violation of any nature, it is always open to the landowner to agitate the same before the appropriate forum. The trial court, the court below, at the threshold, ought not to have refused to or rejected the application for depositing of the amounts. It is always, even after amount is deposited, no prejudice is caused to the respondents, as it is always the respondents are at liberty to agitate their claim before the appropriate forum. In that view of the matter, the order impugned is set aside, and the amount shall be deposited before the LAO shall be permitted to deposit the amount before the court. Next, if the petitioner wants to withdraw the amount and wants to amount, he is at liberty to withdraw the amount, and also if it is permissible, as per the law, if it is permissible, the petitioner is at liberty to question the proceedings if he is so agreed. Accordingly disposed of.
In all cases, not same or only LIC number to be changed.
In all the matters.
Yeah.
Yes. In all the matters, same order, only that LIC number will change.
31.4.
31 point? Oh.
What
is the deceased respondent?
Deceased application not to file. The judge may respond to judge.
Then how can we dispose it of? You appear in which matters? So just see 31, then 31.1, 31.3, 31.4, same order. As far as 31.2 is concerned, the counsel for the petition shall take steps within a period of 2 weeks. List this matter on 27th. Yes.
Seal number 33 for dismissal. Case part. Dharwad.
This is a repetition of 2022. Yes,
I believe the letter might be faster.
yes, pass on.
Number 34.
Yes, give the docket. This is a repetition of 2022. The office objection are not complied with even till now. Right from 28/11/2022 on several occasions, time was granted by this court for complying with the office objections. When the matter came up on 22/2/2024, on that day there was no representation on behalf of the petitioner. Again, a 2 weeks time is granted for complying with the office objections. Again, on 6/11/2024, there was no representation on behalf of the petitioner, hence the matter was directed to be listed today under the caption for dismissal. Today also, there is no representation on behalf of the petitioner. A petition which is filed in the year 2022, even till now, if the petitioner has not complied with the office objection, it appears that he is not interested to pursue the matter. Accordingly, petition is dismissed for non-prosecution. Yes.
Number 35. Diamond. 35 SB Diamond.
This is the same petition of 2022, right from 31/10/2022. The matter came up before this court on several occasions, and on each state, time has been granted for complying with the office objections. When the matter came up on 22/2/2024, there was no representation. Finally, a 2 weeks time is granted to cure the office objections, subject to payment of costs or ₹500 payable to the High Court Legal Services Committee. When the matter came up on 6/11/2024, even as on that day, the office objections are not complied with, and there was also no representation. And this matter was directed to be listed under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Number 36. Number 37. And the starter.
Yesterday we have paid,
You have paid the process.
before also we have paid on February, but they did not consider.
Non-furnishing of deficit court fee of 20. Yesterday, it is submitted by the council that they paid the deficit court fee yesterday, and even before that also, a process fee. Earlier also they have paid, and again they have paid yesterday. The ministry is directed to issue notice. Yes, delete from the caption for dismissal. Yes.
Number 38.
That petition is arising out of
criminal miscellaneous 125 members. In fact, may I come up with the gist, my lords, which will be clarifying the whole issue. 2016 they got married. 2018 they came up with one filing under section 498A.
Furnishing of PF cover, etc., to issue notice to the sole respondent.
Please, I'll definitely issue.
That's what you have to do it first. Do the. This is 13.
8. 3.
The needful shall be done by 11th November, or else the petition should stand dismissed without further reference to the court. Delete from the caption for dismissal. Yes, next.
Once we have given the NOC in this matter, Your Worship, already we have taken the file.
So what did you do after giving NOC? You have to file your memo of retirement with all the details.
Please will file, Your Worship.
When did you give an objection?
Weeks back.
The land council respondent submits that they've already given up wakalat. They shall come up with an appropriate memo before this court by 14th of November. List this matter on 19th.
Obliged.
Yes, next. Delete from the caption for dismissal. Yes, next.
Number 40. Must be denied.
Ready?
Please. Subsequent petition against the order of trial court when the maintenance of 20,000 has been ordered, presuming the salary of the petitioner to the extent of 70,000.
17 or 70?
70.
Hmm.
The petitioner is working as a police sub-inspector in civil rights department. He is not posted to the police station. It is that before the trial.
You have not adduced evidence?
Pardon?
You have not adduced evidence?
No, ma'am.
Why?
Because of his duties and.
Advocate was there.
Please, ma'am.
You should have filed your statement of assets and liabilities.
Now it is ready, ma'am, because now I am.
What is your income as of now?
As of now, today, October 2024, his net salary payable is 51,360.
Give it to her.
Please.
Give it to her and please get instructions on that.
Please.
List this matter on 12th of November. By the time the learned counsel respondents will get specific instructions.
Please. Interim order.
Interim order is extended. Delete from the caption for dismissal.
Please. Wait.
Yes.
Number 41.
Respondent has filed a memo.
Let's see the memo.
Please.
Where is the memo? You are for the?
I'm for the husband. Husband petition. Pending time to Malad.
So what has to be done is,
Yes.
so this order has to be, this appeal has, petition has to be allowed by setting aside that order in the light of the compromise between the parties.
Yes.
The memo is filed by the counsel with the respondent that the matter is settled between the parties in MC number 68 of 2024, which is filed, and a mutual consent decree is obtained on 27/2/2024. Both the parties have agreed to withdraw all the pending cases. The memo is taken on record, and accordingly, the appeal is allowed.
Petition.
The petition is allowed by setting aside the order passed by the court dated so and so. Accordingly disposed of.
Number 40.
Petitioner is, in fact, it is a husband's petition.
Huh?
Husband's petition filed.
Why is it posted for dismissal?
Not paid the PF.
When will you file? Same in the like earlier order, you should pay the process by 11th of November. List is matter on 13th or its default.
I will on 14. Kindly have it on 14 or 12.
14,
Please.
14.
Please. Okay.
Yeah, shall pay the process by 12th. This is marked on 14. Yes, next.
Same with 38.
But delete from the caption for dismissal. Huh?
Same as 38.
38, also same dates. Yes.
Obliged.
Yes, next.
Seal number 43, Mantesh Assessment. Mantesh Assessment.
This is a red petition of 2023. And this court on 12/2/2024 had directed the parties to file affidavit disclosing their assets and liabilities. On 12/3/2024, a 2 weeks time is granted to file the affidavit. And also, the petitioner has failed to furnish the PF for issuing the notice to the respondents. And the matter came up on 5/11/2024. As there was no lesser representation, this court had directed the matter to be listed under the first caption for dismissal on 6/11. Again on 6/11, there is no representation on behalf of the petitioner. Hence directed the matter to be listed on 7/11/2024 under the caption for dismissal. Even today also, there is no representation. In the petition of 2023, neither the petitioner pays the process nor he complies with the order by filing the affidavit. It appears that he is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Seal number 44, Mantesh Assessment.
On 5/11/2024 and 6/11/2024, there is no representation. Consecutively, on those days, the matter came up for dismissal. Today also, the matter is under the caption dismissal. In a writ petition of 2023, so far, the process is not been paid by the petitioner. As such, notice is not issued to the respondents. It appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Number 45, Seeraman.
45.
Petition challenging the grant of interim maintenance. The petition author went filed by mistake this time. Like I will permit it to withdraw it if liberty.
The RPSC is filed against an order passed by the trial family court granting interim maintenance. The office has not raised, the office has raised objection with regard to the maintainability. The office objection with regard to the maintainability is sustained and the petition is dismissed with the liberty to the petitioner to file the appropriate petition. The registry shall return all the record. They shall return the entire record.
Certified copy.
That's what entire record shall be returned.
Seal number 46,
Yes.
Please, I appear for petition, Manoj. It was listed yesterday, Manoj. I comply within 2 days. It's a fresh matter.
Same, 2 days time is granted for complaints of office objections. List is complaints of office objections by 13th November. If the office objections are not complied with, the petition should stand dismissed
Please.
without further reference to the court. Yes.
May I request,
Delete from the caption for dismissal. Yes.
may I request Manoj to comply today? Today, Manoj, during the course, may I request?
During the course of the day, petition is permitted to comply with the office objections. Yes, next.
Seal number 47, Sanjita Kumar.
Huh? The petition is permitted to take steps within a period of by 14th of November, or else the petition shall stand dismissed without further reference to the court.
Still number 48, Prakash Nikki.
Here for the petition. Waive writ petition. Waive writ petition. Let's challenging the order dated numbers 27/6/2024. Order made on numbers IA number 12 and 13.
What is that order?
Let's IA number 12 is filed for reopening the stage of the matters. Reopening the stage. Let's and IA number 13 is filed for seeking permission to cross-examine the PW1.
IA number 12 is to reopen the case.
Reopen.
13 is to further cross-examination.
Cross-examination of PW1 to 3.
When is the MC? Which year is the MC?
No, it's the matrimonial case, which will case for divorce, which is filed with the respondent. Let's on 6/3/2024, in the trial court, matter was posted for matters cross of PW1 to 3 on 6/3/2024. On that day, matters.
I said MC is of which year?
MC is matters. MC 2022.
2022.
MC
When
number.
the trial has commenced?
The trial has.
On 6/3/2024, the matter is posted for the cross-examination of PW1.
29/22.
Huh?
29/22.
Trial has started.
On 6/3 minutes, on 6/3/2024, matter was posted for cross-examination of PW1 to 3 minutes. On that time, minutes, the present petitioner did not cross-examine the PW1 to 3.
Why?
That's the reason is minutes. The present petition is permanent resident of Ryan Gudi minutes. Rayan Gudi, she is situated minutes. It is far away from 400 kilometers. That's why the proper instructions were not given to the council on the property.
Then what happened?
And thereafter, the cross-examination was taken as nil.
Nil. When?
On 6/3/2024. Therefore, subsequently, application was filed.
When is that application?
Application
Date.
on 22/3/2024.
That is dismissed.
Please.
Yes, what's the difficulty? Let
One
me learn.
humble submission. One more opportunity.
Yes.
Now the matter.
Petitioner commenced the evidence on 29/2022. That is PW1.
29.
29/2022. Conducted the chief of the PW1. Objection not filed and cross-examination taken in on that day. And next, 14/2/23. PW2 and 3 examined. And that day also cross-examination of PW2 and 3 taken in. And after 10/3/23, case at the stage of the final argument on merit of the petition. IA 6 is filed by praying to recall and
For
reopen.
further cross-examination. IA number?
IA number 6.
When is it allowed?
Praying filed the permission to filed objection to the main petition allowed on 18/3/2023. And IA number 7 and 8 for recall of PW1 to 3 said application were allowed.
On?
Two application
On.
allowed, and that day again it is posted for cross-examination of petition number 1 to 3 on 13/4/2023. And adjourn on 29/5/2023. And that day rejected the submission and posted for respondent evidence on 4/3/23. On that day. And after that, 4/3/23, IA 10 filed for cross of PW 1 to 3, which is allowed on cost of rupees 10,000, 1,000. And after that, 6/3/23, prayer rejected. And 11/3/24 again posted on, rejected on 11/3/24 and again posted on 19/3/24. Then on 22/3/24, two applications were filed by the respondents.
Yes.
And item number 12 and 13 is rejected on 20.
That's what is impugn order, that I can understand from there.
What
How
the-
can it be?
in-
How many times
in-
the matter will be opened again you don't appear? Why should the court exercise the discretion?
What
How
the-
many times?
What the reason is told there, Your Honor, the counsel is not keeping well. She is suffering from sore throat and infection.
For 3 times.
Not 3 times. 2
Every
times.
time.
2 times.
If it is sore throat,
They are
so
dragging the matter like anything.
please come.
Minutes, one submission. Minutes, one submission. That's some cost. Maybe
No cost.
One
No
more
cost.
opportunity.
I dismiss this revision, this writ petition with cost. With cost of 10,000.
Reason is what?
No reason.
For a moment, can you see the minutes hospital? She is the permanent resident of
Maybe.
Imra in Gudi.
Maybe.
It is 400.
You know, courts have a lot of works to do and not for people like you.
I do agree, minutes. Court has granted sufficient opportunity.
And court will not again redo, undo. No.
Some
This is not the
leniency
case.
may be-
No
some
lenience in this
leniency.
case. Please come.
Reason is one submission. Some minutes cost may be
If you
imposed.
are, no cost.
Final, one more opportunity on that minutes.
We will impose cost for filing this petition
One,
and for abusing the court's time,
one,
for abusing the process of court.
one submission, finally one submission. This honorable court may be fix a date on that time without seeking further time.
Why do
On
you
that-
require this kind of a
Petitioner
treatment?
is also-
Is it you are like, you are at a very elevated from, you are not a common litigant?
The petitioner is also the petitioner is also ready to pay their expenses on that. Pay their expenses. If they are-
What expenses?
That's litigation expenses.
Then we'll say 50,000 cost will you pay, I'll allow this.
Which is, I guess, some fight it.
No,
Because that's one more disease, he has some.
you have wasted the court's time. That is worth more than that before the trial court.
One
How
more.
many times the court will do this exercise for you?
I do
How
agree.
many one?
2 times minutes already.
It's already over. Now you want it to be done 3rd time. Why should it be? There should be some special reasons for that. You don't deserve any kind of treatment.
One minutes, really some.
Why should it be? Please tell the court.
Reason is not, the first reason is.
I can understand. I thought this is the first time.
No.
Then it's fine.
This is
3rd time.
Third time.
What is that your client thinking? That she will do at her own leisure and courts are like, always open for her.
First 2
Whenever
times.
she walks in, walks out.
What happened was second time.
If
First
you are
time
ready to pay 50,000 cost, will do
Well,
it.
first time what happened was she is permanent resident of Imra, she unable to come. And
Second time what has happened?
Second time.
Advocate has sore throat. Advocate has sore throat.
He filed affidavit. Some leniency.
No lenience.
One more opportunity.
Lenience at cost. Cost of 50,000. Otherwise, no.
Like 10%.
No.
He is not paying us any
Maximum,
maintenance.
finally 25,000. Less than that, I'll not order. Please get instructions to pass out.
Please.
25,000, if your client is ready, then we will see. Yes.
48 password. Admission button. Still number 49.
Yes. On the limitation,
Limitation.
according to him, as per the contract,
Yes.
or as per the contract, like once, like that cause of action, he is referring to a particular clause. Where is that clause? Please point out.
So, as per his plaint averments, yesterday he has filed a memo in page 128.
128.
In page 128. In the plaint averments, this clause number 69 is referred to.
128.
minutes. Along with the memo.
Yes, I'm looking at it.
Yes. 128 at the bottom.
Clause number 60.
69. Incomplete or unattended defective works or delays.
Let's read.
Please. The employer has the right to get the uncompleted works done by other competent contractors at the risk and cost of the contractor in the following circumstances. If the contract is terminated for the reasons
attributable to the contractor. If the contractor has delayed the work as per the schedule with no justifiable reason. If the contractor fails to correct any defects in the work within the period stated in the defect notice sent by the project manager to the contractor. If the contractor does not meet any of its obligations within the time frame of the contract specified in section 7 BCC or section 8 BCC. Now, submission of the other side is that only after as per the terms of the contract, only after the retendering work, cause of action starts. But clause number 69, that
So they have to assess how much now the remaining work has to be.
as per section article 55, once the contract is terminated, there ends.
But parties are bound by the contracts.
Contract does not speaks about anything about when it has to be calculated, how it has to be recovered. It is silent.
This is the clause you're relying on, or any other clause?
Your Honor, the earlier to this, the contract was terminated.
When? Please tell the date.
26/4/2012, my lord.
26/4/2012.
My lord. In my statement of objection, there is mentioned.
It's terminated.
Yes, my lord. Then, in the termination order, what was?
How it has to be quantified? The damages, how it has to be
There is a
quantified?
system, my lord. The worst contract, the government norms, PWD norms are maintained. We have to assess it. What happened, just within a few minutes I will tell. Then I will come to that one. Once again the termination order was made, he filed a petition before this honorable, stating that termination is illegal.
So 26/4/2012 is the termination of the contract.
Yes, ma'am.
Then the proceedings before this court were ended when?
The first writ petition was challenged and
11/1/2013.
dismissal on 26/4/2012. Court dismissal by order dated 11/1/2013.
11/1/2013 is the writ petition order.
Yes,
You preferred a writ appeal.
Dismissal, ma'am.
Writ appeal when?
Yes, ma'am.
15/2/2013 writ appeal was dismissed.
Appeal was dismissed.
During writ petition was I had a benefit of interim order of status.
No, let us take it that writ appeal is dismissed on 15/2/2013.
Please, madam.
Then the writ petitions were dismissed on the plea that he should approach the proper court. Therefore, he filed a original suit 130 of 2013, my lord. And he filed it before the junior division of the civil court, seeking injunction damages and return of 7 crore rupees refund by way of performance guarantee for the case. Therefore, we filed the written statement. We stated that junior division has no jurisdiction at all because the payment of 40 is there and 7 crore rupees he has indirectly demanded, and he has not claimed damages in only his suit for injunction. He says that termination should be restored, cancelled, and his contract should be restored. Then we filed the written statement. Then he filed the stay order against the termination order. That was rejected. He filed a miscellaneous appeal. That was rejected. Then he sought from the original court a application mover to stating that he wants a permission of the court to file suit claiming damages separately after disposal of suit 130 of 2013, Your Honor. And that suit is still pending, the cause of action. Then we moved the application, and as per the contract agreement, which is binding on that, and 69 was very clear, there is a system. We have to assess what is the balance of work. There is a system. We issued a notice to you. You attend the particular spot inspection or joint inspection, assess it, and let us participate in it. Then he replied that since the case is pending before the court, will not come up, and all these things. Then third party was asked, because it is a global tender, my lord, Asian Bank Development Support System. The third party inspected, assessed, and proposal was ready about 14 crore rupees balance of work, that much of required. We sent for the approval. Then we determined
that exactly what is, till determination is made technically, we will not be able to say what is the cost involved for completion of the mandate order. Then we served the order on the respondent. We asked him to pay back within 15 days. And then he admitted himself in his reply to the notices that he acknowledges the notices, my lord.
When is the notice?
Yes, my lord. This is the reply of his commitment.
Just tell the court, when is the notice?
He has mentioned it is a reference, my lord. Because it's the original 132. It is, we have not brought on 9/6/2015.
Notice is 9.
Two notices are 9/6/2015.
9
9/6/2015.
is a notice by them.
They see it as a, they term it as an order.
No notice, and your reply is
Reply, copies of them, his reply.
dated
32. And wherein he admits that
13/2. How can it be? Your reply should be after. You say that notice is on 9/6/2015.
yes, sir, they say in the cause of action column, may I read it once again?
No, from K.S. Deshpande so and so to the City Municipal Council. That is on 13/2/2015.
Two replies. One
And
is
another
for,
reply is on
one is
both
for,
are on to 13/2/15 only.
not, in the cause of action limits, may I read?
Both are one and the same. What you have given, no, give him a copy of it. Put on, sir.
6/4.
I think the notice is not.
Notice is not issued, order is passed, my lords. This is, his acknowledgement is here. His acknowledgement on behalf of the respondent, he acknowledged the receipt of notice on two stages. One is before determining actual cost. Then after determining, asking him to pay within 15 days. He denied that, sir, my suit is pending, so we cannot come up. Therefore, he admits that the cause of action pending in the suit 130, still it is
I think
pending.
date of notice is wrong. You replied on 13/2/2015. The notice must have been much prior to this.
Probably, this might be this separate notice, but in the cause of action, what they say is, it is submitted that plaintiff number
No,
one.
no, under these circumstances, sir.
Please.
It's a question of fact and
It
law.
is not a question of fact, Article 55. Other to that, my lord, I find
Let him say, let him say. Yes.
for the compensation of for breach, for the compensation for the breach of any contract expressed or implied not herein specifically provided for 3 years when the contract is broken, or when there are successive breaches, when breach in respect of which suit is instituted occurs, where breach is continuing. In this case, my lords, first part of is applicable because contract is broken. Insofar as successive breach is concerned, once the contract is terminated, question of successive breach does not arise. There is no relationship. Only they have to quantify it. What is the loss they have occurred, and insofar as contention of the
So, like when they have quantified damage, they have to seek damages from you.
Exactly.
No contract is terminated as per the terms of the contract which you have entered. As per that, after the lapses of the termination, then they have to assess the damages to be ascertained or to be collected from you. For that, they did the exercise.
That contract is entirely silent. That whatever they are arguing,
So incomplete or unattended.
yes, they have to get it done from the other side. But it does not say when it has to be recovered. They never say, my lords, only after re-tendering work we will initiate the recovery proceedings from you. That is entirely silent. Point number 69 is silent.
The employer has a right to get the uncompleted
Yes.
works done by the other competent contractor at the risk and cost of the contractor.
On the following circumstances.
So, what is that? Unless and until the other contract is called for, how will they know?
That is not the losses.
In fact, my lord,
No, the law says something and the parties are bound by their contract.
contract does not say. My lord, in fact, similar situation arose before the Honorable Division Bench of the Kerala High Court, wherein also similar conditions were
First,
raised.
let's be clear on the facts, then we'll go to the law.
Yes, ma'am.
So please read it again, 69.
69 is only, my lord,
Step 1, they have terminated your contract. Damages will arise as per clause number 69. The remaining work has to be done by you, done by the new contractor. So what are the amounts that has to be recovered from you? They will know, provided they call for the contract, they call for the fresh tender, and once the remaining work is ascertained, then that would be the cause of action for them to seek damages from you.
but that is not the contract.
That's what
That
you
is
have
not
to,
the-
you have to interpret section 69.
That is what only they say is at the cost of the contractor.
How will the cost be known? So now it has to be, that's what I'm saying.
Assuming for a moment.
Now, we have to look at the section, the
Clause
court-
69.
Court has to look at the documents now, which is not permissible under order 7.
Along with the plaint, whatever documents they produce not, the court can very well look into those documents.
This is filed along with it?
Yes, ma'am.
Have you filed along with the suit?
My lord,
This document is filed?
how file ಮಾಡಿದ್ರು, madam? Your Honor, sorry, I will quote the CPC, a particular provision. I have had the claim, he has not filed the petition.
Huh?
He has not filed the constitutional claim,
Hmm.
number one. So the pleadings before are only claim. And what is the order of CPC says?
Anyhow, for an application under order 7 rule 11, only the plaint averments has to be looked into.
Pardon?
Only the plaint averments have to be looked into while deciding an application under order 7
Plaint
rule
and
11.
returns, only pleadings are, the order is there, my lord, I will read it. The civil procedure code, my lord, the particular order says that while deciding the cause of action, the only plaint and return statement, only our pleadings has to be done. In the pleadings, we have clearly stated when the cause of action arose in the series of things, we issued him a notice. So when the quantum of the balance of work is identified, we issued him a notice to attend, he did not it. Then we determined it, we again asked him to pay back, he did not pay it. On the other hand, he says that, admitted that, this cause of action cannot now lie because 130 suit is pending. It's still pending. It is still being argued in the Bhagat court.
Now, what is his cause of action is different and his cause of action for the relief what he is asking. Your cause of action is for your damages. You have to independently.
Your Honor, distinction that kindly be brought in. Damages for a breach of contract
has not been claimed here. Breach of contract of original has not been claimed here. As per the clauses of the contract, he left the work undone. It is a UGD work. He left it, abandoned the work, digging the canals. There were accidents.
Where did you say in your cause of action that on so and so date, so and so has happened, so my suit is well within the limitation? Come to your plaint.
In page 19, plaint starts.
Let's come to the cause of action portion.
Cause of action 46 minutes.
Yes, read it.
It is submitted that the plaintiff number 1, being the employer of the contract, determined the damages, cost and interest payable by the defaulting contractor defendant by his order dated 9/6/2015 at rupees 14 crores 44 lakh 70.
So whenever you determine the damages, that would be the date when the limitation starts.
Balance of work identified.
Where did you say so?
Yes, madam.
What are the steps?
Yes, ma'am.
Where did you say so in the entire plaint? Please tell the court.
Yes, madam.
Limitation.
You can order 7 of the CPC, rule 11B, madam. That is very important here. Wherein it is stated that the question of cause of action and date of action initiated at such cause has to be gathered out of the plaint filed by
That's
the
why I'm asking you to look at the plaint and tell the court. I'm not at all looking at only cause of action.
Yes, ma'am.
I'm asking you from the plaint, please tell the court. Where did you say all that? It's a bundle of facts we have to ascertain from the plaint.
Yes,
So
sir.
let's see. Where did you say? Again, if you have to read the plaint and tell the court can't wait for such a long time. Please be prepared and come in the afternoon. Let's pass over. Yes, next.
Pay for the petition number. Seeking transfer of GNWC number 2 and 72 members. Family court, Bawal court to my local. The facts of the case number. The marriage of the petition number 1 and the respondent was solemnized at the Balaji Temple, Kadari village, Bawal court, my lord. After that, my lord, the petition number 1 has joined the company of the respondent husband to live the marital life.
Where is the respondent?
My lord, please.
Respondent. Notice is self-sufficient.
The present respondent, present respondent of Saraswati, my lord, 2 and 3, these are the minors of the.
Where is it instituted? GNWC?
GWC, my lord.
Please come to the prayer.
Please.
Bagalkot.
Bagalkot.
Where do you want it to be transferred?
By Bagalkot.
What is the difference? What is the distance?
114 kilometers.
Huh?
114 kilometers. Even though the present
Please
petition
come to
has-
the grounds.
My lord, the present petitioner has filed the criminal miscellaneous, my lord, even though he has not paid the maintenance amount to the present petitioner, my lord. And moreover, my lord, the present petitioner has 2 children. The present petitioner has 2 children, and also petition number 1 residing along with her minor children, petition number 2 and 3, present petition number 2 and 3.
Please come. The present petition is filed seeking transfer of GNWC number 02 of 2022 pending on the file of the Principal Judge Family Court, Bagal Court, to the Senior Civil Judge Court, JMSC, by Hongal for trial. And accounts for the petition submits that the wife had filed criminal miscellaneous number
41 of 2018.
41 of 2018 seeking maintenance. The husband is not paying any maintenance, and the two children. Two
Present
children,
petition number 2 and
the
3.
two children have to be taken care of by the wife. The husband, as he is not paying the maintenance, that itself is becoming very difficult for her to take care of the children. And now, on every date of hearing, she has to travel from bail so and so to Bagal Court. It is submitted that, as this being a GNWC matter, whenever the court directs, she has to take the children along with her. What is the age?
Exactly 10 years.
Who are of tender age, and even that also would be very difficult for her to travel all the way 114 kilometers. Next para. Notice is served on the respondent, and no, there is the notice to the respondent is held sufficient by order dated 15/3/2023. Having heard the accounts for the petitioner, there is entire material on record as per section 7 or 9 of the GNWC Act.
Petition under section 6, 8, 10 and 13.
Do that.
Petition under section 6, 8, 10 and 13 of the Guardian Law.
It's not there. As per section so and so of the GNWC Act, the petition has to be instituted where the minor ordinarily resides. As they were residing at so and so Hongal, the petition was filed for the court. The whole purpose of the said provision is taking into consideration the interest of the minor as and when it is required. The minor has to appear before the court, and as such has to appear before the court. Now in this case, the wife is staying at it is instituted at Bagal Court, and the wife is staying at Hongal, which is 114 kilometers away. And whenever it is required, the wife has to take the children also to the court, which is definitely not in the interest of the minors. In that view of the matter, this court deems it appropriate to transfer GNWC number 02 of 2022 pending before the Principal Judge Family Court, Bagal Court. No, one more thing, that the criminal miscellaneous is also pending to the court at to the Senior Civil Judge at JMSC by Hongal. Accordingly, petition is allowed. Section 9, I think. Section 9. Yes.
Respondent.
Counsel for the respondent is present. No representation for the petitioner. This is matter for discussion tomorrow. Yes.
Short autonomous.
When do you want?
Monday, Tuesday, Mondays.
This is part on Tuesday. No further adjournments
Please, madam.
at the request of non-counsel the petitioner. Yes, next.
Following the order passed by my lords, as per the order, direction discount, I have filed the synopsis on last hearing.
Whose application is this? Wife or husband?
I am the husband, my lords.
What is the amount granted?
Amount granted is 8,000.
8,000. What is your income?
Income is no income, my lords, as in today. Because earlier, my lords, I am doing puja performs as a priest, my lords, in Hanuman.
Why you stopped it now?
Now, due to old age, age of 67.
How old are you?
67. my lord.
And what is the age of the wife?
Age of the normally 60, 62.
Divorce is okay.
No, divorce is not okay. My lord, so what happened, my lord?
Please come to, please come. Come to the impugned order.
Impugned order page number, my lord, 33. My lord. My lord, page number 29.
20.
29. Petition by the petitioner to corresponding matters in 120 Patya cost of rupees 10,000. And the petition granted a maintenance of 8,000 maintenance from the date of the order.
Para 26 also.
Come to para 21.
Please. And the court has declared that the respondent has a sufficient source of income and also whether he is able to provide separate income because he has sufficient means. The two one the petitioner has stated in access that respondent being her husband is having a source of income because of he has 20 acres of land and he is a water resource and he is an irrigated land. He has also working in the society separately and gets a monthly income. And it is a reference that the respondent is also being out of temple puja or temple and gets a sufficient source of income. This case may have that the respondent is actually having sufficient source of income because when the petitioner married him, there was a proceedings of land. The borrower and the respondent is given down a temple in this place and he has gets all over. He can use for them from lender property and therefore he can provide separate income. So far. In fact, I think the recommendation that you can follow clearly to show that the respondent tenants or the name and the letters are transferred by him to the name of his school children from the second. But this finding is against the matter of evidence because as per the exhibit R1, R3, I am not a secretary of the property society. I am just a member of the property society. Second point is, my lord, as per the exhibit, my lord, I have no such land property as stated by the honorable finding given because there's a decree as the exhibit.
In fact, during the cross-examination,
cross-examination, Kannada, my lord.
no, 1 minute. In fact, during the cross-examination, the respondent has admitted that. Just wait. Listen to the court. Has admitted that he is having landed properties around 30 acres and he has got 16 acres for his share. And he also deposes that for the 2 children born through second wife, he has given 5 acres. And he admits that he works as a director in a cooperative society and admits that he is doing the job of a temple pujari. Do you deny that you have stated
Yes,
so?
Yes.
We'll look at the cross-examination. Do you deny that you have not stated so?
I have stated, I have not stated.
Do you have the cross-examination?
I have heard the decree, my lord.
Please read the cross-examination. That relevant portion.
Second round litigation, first time is not remanded.
Let him say.
ಮದುವೆ ನಂತರ ಸುಮಾರು 2 ವರ್ಷ ಆಗಿದ್ದಾಗಲೂ ದಾಂಪತ್ಯ.
No. Please tell the court. Don't have to read everything.
Yes.
This particular admission do you find anywhere?
Para 6.
And ask him to just point out and give it to him. Let him read.
ಸುಮಾರು 20 ಎಕರೆ ಹೊಲ ಮಾರಾಟ ಮಾಡಿದ್ದೇನೆ. ನಮ್ಮ ಕುಟುಂಬ 30 ಎಕರೆ ಹೊಲ ಹೊಂದಿದೆ. ಈ ಅಡ್ಮಿಟ್ಸ್ ಅದರಲ್ಲಿ ನನಗೆ 16 ಎಕರೆ ಪಾಲು ಬರುತ್ತದೆ. ಈ ಅಡ್ಮಿಟ್ಸ್ ಆಸ್ಪತ್ರೆ ಖರ್ಚಿಗಾಗಿ ಸೋದರ ಮದುವೆ ಖರ್ಚಿಗಾಗಿ ಹೊಲ ಮಾಡಿದ್ದೇನೆ. ನಾನು ದುಶ್ಯದ ಕಡೆ ಹೊಲ
ಮಾರಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನಾನು ಬೇರೆ ಹೆಂಗಸಿನಿಂದ ಸವಾಸ ಮಾಡಿದ ವ್ಯಸನಕ್ಕೆ ಒಲ ಮಾಡಿದ್ದೆ ಎಂದರೆ ಸುಳ್ಳು. ನನ್ನ ಪಾಲಿಗೆ ಬಂದ ಜಮೀನಿನಲ್ಲಿ 4 ಎಕರೆ ನೀರಾವರಿ ಸೌಲಭ್ಯ ಇದೆ. ಈ ಅಡ್ಮಿಷನ್ ಲ್ಯಾಂಡ್. ಹೊಲದಲ್ಲಿ ಬಾವಿ ಹುಡುಕಿದ್ದೇನೆ. ವರ್ಷದಲ್ಲಿ 2 ಬೆಳೆ ತೆಗೆಯುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 4 ಎಕರೆ ನೀರಾವರಿ ಹೊಲದಲ್ಲಿ 2 ಬೆಳೆ ತೆಗೆಯುತ್ತೇನೆ. And he admits that from the irrigated land he is taking the crop every two times in a year. ಕಬ್ಬು ಮತ್ತು ಗೋವಿನ ಜೋಳ ಗೋಧಿ ಬೆಳೆಯುತ್ತೇವೆ. ನೀರಾವರಿ ಹೊಲದಿಂದ ವರ್ಷಕ್ಕೆ 4-5 ಲಕ್ಷ ರೂಪಾಯಿ ಆದಾಯ ಗಳಿಸ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ವರ್ಷಕ್ಕೆ ಖರ್ಚು ಹೋಗಿ ನಿವ್ವಳ ಆದಾಯ 50-60 ಸಾವಿರ ರೂಪಾಯಿ ಉಳಿಯುತ್ತದೆ. ನನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ 5 ಎಕರೆ ಹೊಲ, ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ 5 ಎಕರೆ ಹೊಲ ಕೊಟ್ಟಿದ್ದೇನೆ. ಹುಲಗೋಡಿನಲ್ಲಿ ಸ್ವಂತ ಮನೆ ಇದೆ. ಸಹಕಾರಿ ಸಂಘದಲ್ಲಿ ನಿರ್ದೇಶಕನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತೇನೆ. ಈ ಅಡ್ಮಿಷನ್ ಸೊಸೈಟಿಯಿಂದ ನನಗೆ ಉತ್ಪನ್ನ ಯಾವುದೇ ಬರುವುದಿಲ್ಲ. ನಾನು ಸೊಸೈಟಿಯಿಂದ ತಿಂಗಳಿಗೆ 20,000 ರೂಪಾಯಿ ವರಮಾನ ಪಡೆಯುತ್ತೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನಮ್ಮೂರಲ್ಲಿ ಹನುಮಂತ ದೇವರ ದೇವಸ್ಥಾನ ಇದೆ. ನಾನು ಆ ದೇವಸ್ಥಾನದ ಪೂಜಾರಿಯಾಗಿದ್ದೇನೆ. ಈ ದೇವಸ್ಥಾನಕ್ಕೆ ಸುಮಾರು ಜನ ಬರ್ತಾರೆ. He admits all. In fact, the earlier order passed by Dismissal court may find this. Earlier order. There is a direction to pay the monthly maintenance of 7,000 from the date of petition up to the date of disposal of the criminal misdemeanor as a interim measure.
Yes, let him say.
Yes. It's the second round litigation. Earlier I have challenged, the respondent has challenged before this honorable court respect to my lord the order dated 23/4/2015. In that tab number 15 shall I read in earlier orders. It is not the case of the petitioner that there was a panchayat and in the year 2010 regarding payment of maintenance, and in the said panchayat she has received 1 lakh or rupees 2 lakhs maintenance. Therefore, she is in need of enhancement of maintenance. Her case is one of the total denied. On the other hand, the aforesaid matter in the form of cross-examination of PW in page number 5 and evidence of RW1 to R4 and pleading of the responding tab number 12 goes to show that earlier in the form of examination in tab number page number 5 and evidence of RW1 to RW4 and pleading of the responding tab number 12 goes to show that there was a panchayat held in year 2010 regarding payment of maintenance, and in the said panchayat there was an agreement for payment of 2 lakhs from the respondent to the petitioner, and out of such agreement he has already paid 1 lakh by way of fee. It is also stated that he has paid another 1 lakh by way of cash to Rangaponi to the petitioner, and he is nothing to pay to her. Then there was an agreement between the parties for payment of maintenance in the year 2010, and as per the petitioner's version, she has received rupees 1 lakh by way of fee. She ought to have discussed that material aspect before the court. She has not whispered a single word about the previous arrangement made for maintenance. In that ground, my lords, in the family arrangement, she has received 1 lakh. It is admitted in the cross-examination. And second is, my lords, as per section 25 subclause 4 of the CRPC. So the marriage is taken from 1981, and she is left the house in 1982. So from the 1982 to my lord 2012 she has approached. There is no communication between the respondent and the petitioner. So means she has sufficient means, and she voluntarily left the house. And third is, my lord, as per the earlier this honorable court directed to make limited evidence in respect of the maintenance, my lord, that have to read, my lord, this honorable court in that is under law number 17/123.
Yes.
And 23/123. In the exact cross-examination of the my lords of petitioner husband, in that he has stated ನನಗೆ ಈಗ 66 ವರ್ಷ ಆಗಿದೆ, ಈಗ ನಾನು ಉದ್ಯೋಗ ಮಾಡ್ತೀನಿ, ನಾನು ಈಗ ಕುಲಗೋಡದಲ್ಲಿ ಇರ್ತೇನೆ. ನನ್ನ ಮದುವೆ 1981 ಮ್ಯಾರೇಜ್. ನನ್ನ ಮದುವೆ ಆದಾಗ ನನ್ನ ತಂದೆ ಹೆಸರು 40 ಎಕರೆ ಜಮೀನು, ಇದರಲ್ಲಿ ನನಗೆ 20 ಎಕರೆ ಮತ್ತು ನನ್ನ ತಮ್ಮನಿಗೆ 20 ಎಕರೆ ಜಮೀನು. ನನಗೆ 4 ಜನ ಸಹೋದರರು. ಅವರ ಮದುವೆ ಇಬ್ಬರಿಗೆ ನಾನು ಖರ್ಚು ಮಾಡಬೇಕು, ನಾನು ಇನ್ನೊಬ್ಬರಿಗೆ ನನ್ನ ತಮ್ಮನ ಖರ್ಚು ಮಾಡಬೇಕು. ಆ ಜಮೀನಿಗೆ ಒಣ ಬೇಸಾಯ ಇದ್ದ ಕಾರಣ ಹೆಚ್ಚಿಗೆ ಹಣ ಬಂದಿಲ್ಲ. ನನ್ನ ಸೋದರರ ಮದುವೆ ಮತ್ತು ಬಾಣಂತನ ಅಂತ ತುಂಬ ಖರ್ಚಾಗಿದೆ. ನಾನೊಬ್ಬ ಸೋದರ 4 ಎಕರೆ ಮಾರಿ, ಇನ್ನೊಬ್ಬ ಸೋದರ 4 ಎಕರೆ ಮಾರಿ ಮದುವೆ ಮಾಡಿದ್ದೀನಿ. ನನ್ನ ಕಷ್ಟಕ್ಕೆ ಅಂತ 4 ಎಕರೆ ಮಾರಾಟ ಮಾಡಿದ್ದೀನಿ. ಆದ್ದರಿಂದ ನನಗೆ ಫುಲ್ ಎಂಟೈರ್ ಹೋಗಿ ಅದನ್ನು ನನ್ನ ಮಗ ಸೊಸೆ ಹೊಡೆದಿದ್ದಕ್ಕೆ ನನ್ನಿಂದ ಕಸಿದುಕೊಂಡಿದ್ದಾನೆ. ಸೊ ಮೈ ಲಾರ್ಡ್, ದ ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ husband disclosed that earlier he had 40 acres. There is a division between the brothers. He has got, my lord, 20 acres. Out of that, my lord, he has spent 4 acres and another 4 acres sold to the marriage of his brothers and sisters, my lord. Remaining these kept in 8 acres. Thereafter, my lord, he made a decree. So son has filed a suit against him that was transferred in the name of as per decree, that is Exhibit R9, my lord, I have found. That he has now today he has no land in his name, my lord, as per the Exhibit R9. That is Exhibit R9 I have produced, my lord. That is the decree passed by the second additional civil judge and JNFC broker. So considering this, my lord, and earlier proceedings and the cross-examination, what happened, my lord, she has clearly admitted that she has left the house of 1983 and she has received the amount of 1 lakh rupees. So on that time, my lord, this honorable court, that is honorable district judge, has complained that there is a previous arrangement between the parties and she has not suppressed the earlier arrangements before coming to the court. On that ground, it is set up by 1 lakh, my lord. That is, under that was suggested at this honorable court and redirects after the evidence, my lords, which will come to the court, the evidence given by the finding given by the single judge, my honorable session judge in car number 21, against the evidence. Because from 81 to 2012, there is no communication. So they have not disclosed before the court. She has land in her father, my lord. So that was not disclosed. They have sold to her brother, my lord. That was not disclosed. And till today she has sufficient income. And fourth point is, my lord, as for the Gosha system of that family, Gosha, that is system in that family, my lord, they never come to the court. They never come to approach the court. That was admitted in the cross-examination by her. So on that reason, on 2012, my lord, they have made a family arrangement. On that reason, we have paid 2 lakhs. So
they have not appeared before the court.
She has admitted. I have showed it for you.
She has not appeared before the court.
She has appeared. She has appeared and
she has given the evidence. I have shown the court examination.
Given the evidence. And all that.
I showed before this honorable court that she has admitted in the cross examination.
If she is admitting in the cross examination, that means she has come to the court.
No, not that. She admitted she belonged to Gosha system.
She has come. Where she admitted, before the court or not?
Before the court, ma'am.
That means she has come to the court. Just now you are submitting that she will not come to the court.
She has come to the court, my lord. She has given evidence and she admitted.
Yes, yes.
And second is, my lord, she has admitted that she has received, there is a panchayat before the Goka, and she has received 1 lakh rupees. That is given by the earlier honorable district judge.
Yes.
On that review, my lord, this honorable court allowed him.
Yes. Please come. Agreed with orders passed in criminal miscellaneous number 238 of 2012, dated 6th March 2023. The husband is before this court. By order reviewing, the court has granted an amount of rupees 8,000 as maintenance to the wife. The facts of the case are: the wife had filed a criminal miscellaneous seeking maintenance, and that came to be disposed of on 23/4/2015, wherein the husband was directed to pay permanent alimony of rupees 1 lakh. Against that order, RPFC number 1000096 of 2015 is filed before this court, and by order dated 10/6/2022, that came to be set aside, as there is no provision for grant of permanent alimony under 125 CRPC, and directed the court to decide the matter afresh.
Interim arrangement was interim arrangement, my lord, 7,000 was.
And as an interim arrangement, the husband was directed to pay 7,000 to the wife during the pendency of the
from the date of petition.
From the date of petition till the date of till further orders to be passed by the court.
Till the disposal of
Till disposal of the petition.
That order, my lord, is intact. Even, my lord, that are held by the Nagaland district judge. While, my lord, that should be.
The trial court, by order impugned, had granted an amount of rupees 8,000. While granting the same, the court has observed that during the cross-examination, the husband has admitted that he is having landed properties around 30 acres and he has got 16 acres for his share. And he also proposes that for the 2 children born to the second wife, he has given 5 acres. And he admits that he works as a director in a cooperative society and admits that he is doing the job of a temple pujari. I am reading from the order. I will record your contentions. Yes. Job of a temple pujari. The court observes that what has been stated by PW1 is what has been stated by the wife is admitted by the husband in his cross-examination, though he denies that he has given away his share of land to his son. The court observes that to overcome the maintenance order, he has transferred the land to the name of the children. As was number 400 of 2020 is a suit which is filed recently. And the petition for maintenance was filed in the year 2012. It is to be, the husband deposes that 20 acres of land given to his share has been sold to an extent of 8 acres to meet the expenses of the sister's marriage. But he admits that same kind of share was given to his brother, who also had the responsibility to perform the marriage of the sisters. But his brothers had not sold any lands. The court observes that it is very difficult to believe that the respondent has sold away his property and that he has no income or properties as of now. The court further observed that the witnesses who were examined on behalf of the husband as RW1 to RW4 speaks to the contrary. As RW1 admits that there is a temple in their village and the temple priest is a husband, and many people visit the temple, and he admits that husband is a member of society, and it is also admitted by RW2 that the husband is having 10 to 12 acres of land with irrigation facility, and RW3 admits that the husband is having 10 acres of land which he has transferred to the name of his children. He deposes that on every hearing date, the husband comes to the court by hiring a car. Court comes to the conclusion that the respondent is quite rich and capable of maintaining his wife, and he has sufficient source of income. Full stop. Court has considered the evidence of RW4, who pleads ignorance that the husband is having sufficient source of income from the landed properties, but he admits that he is having sufficient land and he also has a vehicle which is used for hiring. Court also taken note of the fact that the husband has got marked the document to show that he has paid some payments to DD to the wife, but payment of rupees 1 lakh is admitted by the wife, but it cannot be termed as maintenance for the wife for the whole life unless she admits that the amount was given to her is a permanent alimony. Exhibit R1 is produced to show that the husband is not doing any work in the society, but he is only a member. Exhibit R2 encumbrance shows that there is a land measuring 10 acres in survey number 450/6, and it is standing in his name. Exhibit R9 is a compromise decree passed in favor of the son of the husband, and the land standing in the name of the husband has been entered in the name of his 2 children. The court observes that these documents will go a long way to contend that he has no source of income and transferring his lands to the names of his children will not save him from the liability of maintaining his wife, that too when he has entered into a second marriage during the subsistence of the first marriage. Considering all this, the court has come to the conclusion that the wife would be entitled for maintenance as she requires money for her food, clothing, and shelter, and also for medical requirements. The respondent is having sufficient landed properties and an income and can provide a separate maintenance to the wife and accordingly granted an amount of rupees 8,000. The court has also taken note of the fact that this court, while passing orders in RPFC number, had granted rupees 7,000 as interim maintenance. Therefore, the order of rupees 8,000 granted is from the date of order but not from the date of petition, and accordingly passed the impugned order. Agreed thereby, the husband is before this court. The counsel appearing for the husband has put forth the following contentions. Number one, A. He submits that because of the old age, now he is not working as a pujari, there is no income for him. The properties which fell to his share, part of it has been sold for performing the marriage of his sister, and part of the land is now transferred to the son. Next. By way of in view of the compromise decree. In view of the compromise decree passed by a civil court. Next. The findings of the court that he is working as a director in a cooperative society is contrary to his evidence, as it is his case that he is only working he is only a member in the said society. Next, there is sufficient evidence on record to show that the wife had deserted the husband. A wife who had deserted the husband is not entitled for maintenance, and this aspect was not considered by the court. Next point. He is not having sufficient income. When he is not having income, question of he paying a maintenance of 8,000 does not arise, and the maintenance that is granted by the court is contrary to the material available on record. Anything else?
And she has left the house from 1982.
Huh?
She has left the house.
That I have written desertion. Yes, next.
Next is, my lord, she is not entitled for maintenance. She is section 125 4 my. So
that's what I said, that because she is deserted and 125(4), she is not entitled.
Yes,
all contentions are answered. The next paragraph, then comes an appearing for the respondent. Wife submits that court has considered. Basing on this, then in his contentions, basing on these contentions, then counsel submits that the order impugned is liable to be set aside. Then counsel appearing for the respondent, wife submits that the husband during the subsistence of the first marriage has contracted a second marriage, and when the criminal misdemeanors is filed in the year 2012, in the year 2020, by way of a collusive suit, they enter into a compromise and he transfers the properties that are the property that is enters to a compromise decree and transfers the land in the name of the son. The court has also considered the evidence of RWs 2 to 4 and the lifestyle of the petitioner, and all these things disclose that the petitioner husband is having sufficient source of income, and the court had rightly granted maintenance of an amount of rupees 8,000 and no 8,000. He further submits that the evidence of the petitioner was rightly considered by the court, and which shows the petitioner's financial position and his ability to pay the maintenance. And the court had rightly granted the maintenance, and no grounds are called for. in this petition to interfere with the well-considered order passed by the trial court. Next part. Having heard the counsels on either side, produce the material on record. This is the second round of litigation. The criminal miscellaneous is filed in the year 2012. In that, the court had granted 1 lakh as permanent alimony, which is found fault by this court as there is no provision under section 125 for grant of permanent alimony. And however, while demanding the matter to the court had granted maintenance of an amount of Rs 7,000 to be paid by the husband from the date of petition till the disposal of the petition. And
That amount has also not been paid by obtaining a stay order from the son.
in this
That
case,
is not the case. That is not the case.
He is not allowed to proceed in that.
it is a case of the wife that even till now, he has not paid the money as ordered by this court.
No, no, madam. It's a different matter. No.
His contention is not made by the husband. This court had perused the order passed by the trial court and the evidence written before the court. Though making a submission that he has sold away the property for the purpose of a marriage of the sister's daughter, and he had transferred the lands in the name of the son by way of a compromise decree. And the evidence of the witnesses appeared on behalf of the respondent, that is RWs 2 to 4, their evidence and the evidence of the husband crystallizes that the husband has a decent earning and a decent living apart from the landed properties. The manner in which the compromise decree is entered and the manner in which the property is sold, all that clearly shows that with an intention not to pay the maintenance to the wife. Why? All these transactions were done by the husband. A person without even obtaining a divorce and during the pendency of during the subsistence of a first marriage, who contracts a second marriage cannot afford to come before the court and tell the court that in a suit filed by the son from the second marriage, he has entered into a compromise and he has given away the said property. And as rightly observed by the court, all these affairs from the husband shows that only with an intention to avoid the payment of maintenance, the husband has come up with these kind of transactions. In that view of the matter, this court finds no reasons to interfere with a well-considered order passed by the trial court, and accordingly, RPFC is dismissed.
Observation, but otherwise, they may say that from the date of order, from the date of petition to Malad.
What is that?
From the date of petition to Malad.
So that 7,000 is from the date of petition till the disposal. And this order is from the date of order.
Yes, that may be intact, it can be recovered. One observation.
As the order of the court, trial court is not interfered with by this court, the wife is at liberty to recover the amount as per in accordance with law.
Please.
Yes, next. Yes.
Please, my lord. I am appearing for the revision petitioner, my lord.
Who is the revision
In
petitioner?
the connected petition for the husband, my lord.
You are for the husband.
Lord, my submission is, my lord, recently I have filed the wakalat in this matter after obtaining the NOC. The short accommodation.
When do you want?
Lord, after 2 weeks, my lord.
No, 2 weeks is for RPFC. You don't require such a long time. No. Will
Obtained the interim order is there.
Huh?
It is an interim order in matter, my lord.
So
It's also a connected petition.
list this matter on 19th. No further adjournments will be granted. Look at it. If there is an interim order, extend it till the next date of hearing.
In my
One submission. Yes, in the meantime, efforts may be called for reason that several changes are produced by virtue of which not see transfer the property.
The registry is directed to call for the lower court records. It's
Already
there,
there.
it's already there. Yes.
Great.
Yes, next.
Take
Please.
Yes, next.
55 cross to 9, which what?
Yes, petitioner has already joined back the matrimonial.
No, they are residing cells together.
English, we could not be able to present the petition or respondent before this Honorable Court.
So basing on the instructions, you can file a memo.
You can file the memo.
We'll list it on Monday. List this matter on Monday. So filing a memo, that's
Since
what
father
time.
of the petitioner is hospitalized, for that reason.
List
they
this
could not
matter
do-
on 19th.
Please.
It is submitted that the matter is already settled and the parties are living together. Yes. Is 56?
Number 56. Chetan, can you repeat that?
Yes.
Wives and his daughter, region, kindly pass over the matter.
So, yes, after lunch.
serial number 23, my lord.
No adjournments.
No, my lord. Interim, my lord, may kindly extend. Already it was.
If it is there, they will, even if you don't ask, they will adjourn. They will extend it.
Please, serial number 98, this dispose of matter is settled before the family court.
Take that. Except this kind of disposals, or if the matter is dismissed for default, then only make a mention. Otherwise, please don't make. Which is this? 90?
Family court order, 98, my lord. 98. I produced the family court order.
This is filed by whom? RPFC?
Please, sir.
RPFC is filed by whom?
Myself, and for the prisoner.
Petitioner, what, husband or wife?
Husband, wife.
Husband.
Yes.
It is submitted by the land council that the matter is, the parties have amicably settled the matter, and the marriage is dissolved by order dated 18/2/2018, and the memo is filed to that effect. Hence, the petition do not want to, but it has to be set aside. In view of the settlement between the parties, the order impugned, the order in RPFC is set aside, and accordingly, petition is allowed in the light of the compromise entered into between the parties. Give that. Passed over. 60. A memo is filed. 16. Huh? 16. 16. A memo is filed stating that. What is this? Again, you are seeking for a fresh petition or appropriate petition. Why? Then you step it off. Please, come on, call it after lunch.
You're right. You are 60 for the life and installment.
Thank you.
external. ಸರಿ ನೀನು ಬರ್ತೀಯಲ್ಲ
dismissed as not pressed. Accordingly, memo is taken on record and the petition dismissed as not pressed. Yes. Next.
Seal number 30, password. Field part.
What is this content?
Field part.
Morning they were there.
Morning they are submitted for pass.
Just inform him.
Please.
And once he comes, please inform the court officer. Will take up. Yes, next. Yes.
Seal number 48, password.
Yes. What are your instructions?
On 30th January 2023,
Use the mic.
on 30th January 2023, the present petitioner filed an application, and on that day, interim application was allowed, and 8,000 was granted to the petitioner, and 10,000 litigation cost was also awarded. Till this day, they were not awarded.
That's not the concern of
One word. This is one submission. And apart from this one, there was a settlement talks on this going between the
Let it go on.
going between the both parties. That's why we have not cross-examined this second submission.
You said so in your petition?
Please.
Yes.
But
No, what happened to sore throat?
No, but
That was the reason. Advocate filed the affidavit. And then where from this new fact has come into light?
No. Already in my affidavit and as well as my petition, I have pleaded. And admitted.
No, again we will remind the matter that remains to be the same, that there are compromise talks are going on, and this is the season is for cold and cough. Again, the advocate will have a sore throat.
But admitted fact is not.
No admitted facts.
They have not filed minutes.
No, the matter is only passed over for that aspect. If you are ready. What is reasonable? Court already said what is reasonable. Well discussed.
Reason is another reason.
It is that the litigant understands.
The petitioner mother.
Just as a matter of course and matter of fact, just like the things won't happen. And now it is not his house that whenever he comes, want to come, will come and go, will go.
Seek apology. But another mother, the petitioner mother is met with an accident. Met with the accident. Petitioner mother. But she has to take care.
But please understand, it's all like, all that kind of cards shouldn't be used. No, for you contesting the matter, it is not, this is not relevant to consider this application. Accident of the petitioner's mother and all.
Moreover, he has petitioner having 2 children. She has to take care.
Should have been more vigilant. Instead of wasting court's time and her time, she should have pursued with the matter. Please come.
Reasonable.
Agreed with the orders passed in.
And the brief on submission.
Yes.
And the cost may be payable to the parties.
Party. The agreed with orders passed in I number 12 and 13 in MC number 30 of 2022. The wife is before this court. Who filed the MC?
His husband, respondent.
The respondent Karen had filed MC number. It's for divorce. MC number 30 of 2022, seeking divorce. The present application is filed. That's I number 12 under section 151 CPC. I number 13 under order 18 to 17, trying to reopen the case by recalling the order dated 16/2024 and recall PW1 to PW3 for cross-examination. The said application came to be dismissed and while dismissing the said application, the court observes that the evidence commenced on 29/2022. As on the day the wife was examined in chief, the husband was examined and the objections were not filed and cross-examination was taken as well. And on 14/2/2023, PW2 and PW3 were examined. Their opportunity was given for cross-examination, but there is no defense of the respondent side. And on 14/2/2023, cross-examination of PW2 and PW3 was also taken as well. Then on 10/3/2023, case was at the stage of arguments on main petition. Then the wife had filed IA number 6, seeking permission to file objection to the main petition. An application was allowed, and then on 18/3/2023, the wife had filed IA number 7 and 8 for recall of PW1 to PW3, and such application was allowed, and again posted for cross-examination of PW1 to PW3 on 13/4/2023. On that day also, witnesses were present before the court, and the respondent counsel submitted that the senior is not well, and then again matter is adjourned to 29/5/2023. On that day also, PW1 to PW3 were present, but respondent counsel, that the vice counsel was not ready to cross-examine. Once again, the prayer was rejected, and cross-examination of PW1 to PW3 was taken as well, and court case was posted for respondent evidence. And again on 5/6/2023, IA number 9 is filed with the wife to recall PW1 to PW3. And the said application was allowed on 12/6/2023 on cost of ₹5,000. And again, case posted for cross-examination of PW1 to PW3. And thereafter, matter adjourned on several dates. On 19/2/2024, PW1 was present, but the vice counsel has taken time and again matter posted to 29/2/2024. On that day also, PW1 to PW3 were present and respondent counsel was absent. And on that day again, cross-examination of PW1 to PW3 was taken as well, and case is posted for respondent evidence on 14/3/2020. Then on 14/3/2020, IA number 10 is filed by respondent by wife again to reopen the case and recall PW1 to PW3 for cross-examination. And again, the said application was allowed on cost of ₹1,000 as last chance for cross-examination of PW1 to PW3. And again, case was posted. Then again, even after that also, the counsel was absent and the matter was posted to 16/2024. On 16/2024, PW1 to PW3 were present, and on the day, counsel for the wife was absent, and another advocate filed adjournment application that was rejected, and matter was passed over, and again called out at 1 p.m. At that time also, PW1 to 3 were present before the court. Respondent counsel was absent. One advocate appearing on behalf of him raised time for a cross-examination, and the same was rejected. A sufficient opportunity was given. Again, case posted for respondent evidence on 11/3/2024. On that day also, whenever I say respondent, it is wife. Whenever respondent, I say it's wife. On that day also, the first calling hour, wife was present and matter was passed over, and again called at 12:45 p.m. For that time, the counsel was again absent and the matter was posted to 19/2024. And then on 22/3/2024, on that day, that is on 22/3/2024, the wife has again filed these two applications, stating that on 9/6/2024, the counsel was not feeling well and suffering from fever and throat infection, hence not able to appear before the court. To prove the same, the documents were not filed. The court, considering the manner in which the matter underwent adjournments and how negligent the wife is, the court had dismissed the application. Agreed thereby, the wife is before this court. When counsel appearing for the wife submits that a final opportunity has to be given to the wife, it is submitted that because of the ill health of the advocate and also the fact that the compromise talks are going on, they have not cross-examined the husband. He submits that even the wife's mother had met with an accident, and under these circumstances, a final opportunity may be given to the wife. Next paragraph. When counsel appearing for the respondent husband submits that the order impugned discloses the manner in which the wife is prosecuting the matter and how she has abused the judicial time and how many adjournments were sought. Court, having considered all these aspects, had dismissed the petition, and there are no grounds to interfere with the well-considered order passed by the court. Anything? You want to say anything? With the well-considered order passed by the court. Next one. Having heard the counsels on either side, peruse the material and non record. On 3 occasions, on 3 occasions, the court had allowed the application to recall, reopen on cause. In spite of the same, on the 4th time, again the wife had come up with another application, and now the very same submissions which were made earlier before the trial court are made before this court. These kind of approach the party cannot be appreciated, and the courts shall not show any kind of indulgence on these parties who are not vigilant and in fact who are trying to drag on the matters. They are not only wasting the judicial time and also giving a lot of inconvenience to the other party. And ultimately, while deciding any applications, court has to look at the substantial justice, and in that pursuit, this court deems it appropriate to give a last and final opportunity to the wife. Accordingly, the following court is passing the following order. Number 1, the order impugned is set aside, and the IA number 12 and 13 filed by the wife is allowed on the condition that she shall pay an amount of ₹20,000 to the husband within a period of 2 weeks from the date of receipt of the copy of the order. Next, the court shall give a specified date, and within the set specified dates, the wife shall cross-examine the husband. Under any circumstances, on the request of the wife, the case shall not be adjourned, and within a reasonable time frame, the cross-examination shall be completed by the court. Accordingly, petition is disposed of.
Not only PW 1 to 3, cross-examination, PW 1 to 3.
1 to 3. Yes. Next.
My lord, the whole case has arisen on his application before the trial court under order 7 rule 11B, my lord, which is meant for rejection of the plaint at the threshold, my lord. And 11B very clearly says that on the face of the plaint only,
On the prima facie, if it is barred by any law, the plaint can be rejected. The Honorable lower court heard the both parties in detail and gave a very speaking order, my lord. Only few claims are required for reiteration to make my position clear as a respondent, my lord. The order has been enclosed by the
No,
petitioner.
you want to show something from the plaint. That's how it is
Plaint, I am
adjourned.
showing, my.
No, first to show that how many
Yes, ma'am.
times the court will hear the matter again and again.
Plaint has been enclosed by the.
Please show the court that where is your cause of action.
Yes, ma'am. At page number, he has enclosed, my lord. At page number 70, my lord. Cause of action paragraph.
That I've seen. If you see that cause of action, that's not the cause of action.
Yes.
How can it be that? How can that be the cause of action?
Yes.
You were saying
May I read it, my lord?
You were saying before noon that in the plaint you have stated when the cause of action has arose for you.
Yes, ma'am.
That's how it is adjourned.
Yes, my lord.
Please come to the plaint and show the court where did you say that as per the terms and conditions of the agreement, like once the contract is given to the third party, as per the same your cause of action arose for you. Where is that?
I have to read the content of the plaint.
Which para? For that only it is adjourned. You have a stay in your favor?
Minutes?
In this there is a stay?
Yes, ma'am.
List this matter after 4 weeks. Yes. And tomorrow all granted is extended deadline. That's it. Yes, next.
Wife representation. In respect of wife, no maintenance is ordered. In
wife?
No maintenance is ordered in respect of wife.
What is the ground why it is not ordered?
The reason is that the respondent has not neglected the present petitioner.
Oh, let's come to that.
Para number 13. Page number 13.
Read.
So by looking into the evidence of PW1 and the RW1.
Para 13.
30.
30.
Yes. Before that 29 may be read. May I read this?
So, para number 29.
Please. So, on the perusal of the entire evidence of the petitioner and respondent, it is clear that the respondent has not neglected nor refused to maintain his wife and daughter, and he has not caused any kind of harassment to the first petitioner. The first petitioner has filed this petition only because she left the house of her husband voluntarily, that too, and on a demand that he should make a separate house for her, and that house should be made only in Dharwad. So, only for the reason that a separate residence is not provided to her, she has left the husband, the respondent, and filed this maintenance petition. She has not got examined any witnesses to substantiate that there was any kind of harassment or ill treatment by the respondent. So her demand to stay in separate house and refusal of the respondent to make a house separately, that too in Dharwad, would not be a ground for the first petitioner to seek maintenance. It would not be a ground for the respondent to take maintenance. So by looking into the evidence of the PW and then the RW1 to 3, it is clear that there is no neglect or refusal by the respondent to look after his wife and the daughter. But it is the first respondent who has left the matrimonial home without any reasons or without valid grounds. She has left her husband voluntarily for the best reasons known to her. So therefore, I hold that first.
You have filed MC?
No, ma'am.
The matter has been referred to mediation center, my lord. The present respondent has agreed to take her wife and children, my lord, but she is not willing to come with him, my lord. And only her contention is that she has to make an house in Dharwad. They are resident of Shimoga, my lord. He is residing with his parents, my lord, and she also knows that the father-in-law is suffering from spinal cord injury. Hence, my lord, he is taking care of his father, my lord. And moreover, my lord, one more brother is there attached to said house, my lord. Recently, hardly from 3 months back, my lord, he got injured and major accident has been occurred, my lord, and he is not able to see his parents also, my lord. Hence, her condition, moreover, the present respondent is a coolie, my lord. He is taking care of his parents and he is residing there. He is taking care of his wife and children also, my lord.
What is a reasonable cause for you to stay away from the matrimonial home?
Reason is not kindly see para number 2 of the very same order. Petitioner was subjected to cruelty. Therefore, minutes she has constrained to stay with her mother at Dharwad. That was not.
No, that's a different aspect. You say that you come to Dharwad and stay with me, then I'll stay.
No, minutes. Some of the minutes kindly see the evidence portion.
Let's see your, what is that you said? So, para number 2 itself we see.
Para number 2 of the petition. The respondent has not elicited any minutes to marriage is number 11. The first petitioner met with the respondent on 2/11/2017 so and so as per the custom prevailing in their community. Therefore, the first petitioner joined the company of the respondent in his residence and lived together. Lived there. But in the matrimonial home, she was unhappy because no affection was shown by the husband and his parents. The petitioner became pregnant and expected respondent to change at least in the future. The respondent was taking alcohol every day and used to come to home late and quarrel with the petitioner number 1, blaming in her country language. He was demanding money from the parents of the petitioner number 1, and nobody came to the aid of the first petitioner. The petitioner cooperated all the acts of the respondent with the hope that the things may correct itself in the future. But the respondent was cruel and had no courtesy for the petitioner. Even during pregnancy, he has not taken any proper care of the first petitioner. Then she delivered a child in October 2018, and after delivery, the respondent came to Dharwad and stayed for 2 days, but he did not bother to provide medical aid to the first petitioner. He did not spend any money for the child after the delivery. And even during the Chowda ceremony performed for the child, he did not bother to attend the function. The respondent, his family members, had no care for the petitioner and never offered anything to them. They were quarreling with the petitioner and abusing her in Hindi language. They also insisted the petitioner to sign US papers, and unless she signs those papers, she could not come to their village. She has totally neglected and refused to maintain his wife and the child without any cause of the cause. He refused to maintain them. He has not provided the basic amenities to the petition number 1 and 2. It has become difficult for him. This aspect is not considered within the trial court. Even otherwise, once marriage is admitted, they are not
From para number 18, my lord. And page number 21, my lord, para 18. From para number 18 onwards.
Mallards, kindly see the Mallards. Even Mallards, during pendency of this petition, this matter was referred for mediation. This mediation report is also available on record. Kindly see the mediation. Conduct of the Mallards is noticed by the mediator.
Where is that?
The report is available in the record.
There is a mediation report.
Dharwad.
Respondent is not coming forward for settlement.
Settlement in the sense, my lord.
Hence, the petition is referred back to the court.
The settlement is a once for all settlement, seeking divorce, my lord.
No,
This was the fact, my lord. In front of the mediator, the matter has been referred. Even the elders were also present, my lord. Even for the elders also, they are expected to appear and discuss about the one-time settlement, my lord, for seeking divorce, my lord. And more, can you say paragraph number 18, my lord? from para number 18 of the judgment, page number 41, my lord. Para number 18. That possibility is more in this case because PW1 in the cross-examination has admitted that her father-in-law is suffering from illness and that her husband is being fully worked and he has to take care of them. It is suggested to her that when she stayed in the house of the respondent, she was not ready to do any household work and that she used to get up at 8 or 8 a.m. in the morning. And she has denied. It is suggested to her that because she was not doing household work but was getting up late in the morning, the respondent has advised her.
This kind of inquiry, how can the courts do? No. Like she says that she has a cause to stay away from the husband, from the matrimonial home. And what are all these inferences?
My only submission before Lordship is
according to now, she wants him to come and stay in Dharwad. She has been harassed there.
Please,
so she has a reasonable cause to stay away from the husband because he is regularly consumes alcohol. She has a story for that. Her own story.
These are all created matters.
The courts, when 125, when under 125 CRPC 125(4) says that a person, a lady who is staying away from the husband without a reasonable cause is not entitled for maintenance, that doesn't mean that the courts have to do this kind of an inquiry as if they're doing it in a criminal appeal.
In her evidence only wherein she has clearly admitted that she is not willing to reside there, my lord.
Because
even the evidences of her evidences and dependent evidence, which clearly says that the husband and even his family members have never treated her, my lord.
Where did she say?
Please, my lord. Page number, para number 24, my lord. Para number 24.
Please read.
Now I go to the evidence of respondent and these two witnesses. R1 is the husband of the petitioner who is examined in this case, and he has deposed that he married the first petitioner in the year 2017. And she came to his house and started the marital life. But she has now filed this petition making false and baseless allegations against him. Though he has taken proper care and looked after her with love and affection, he deposes that she was unhappy to stay with him because his parents were living with him. And that his father is bedridden due to backbone problem. This is evidence that she never used to cook food for him and his parents. When first petitioner was pregnant, they have performed the baby shower ceremony and then sent her to paternal house. He deposes that she was admitted in SDM hospital and respondent has taken care of her and the child for 8 days, and then he dropped his wife and his children to the house of the parents and he was going frequently to see the children. In his, it is his evidence that after the delivery, when the first patient came to his house, she stayed only for a week and claimed that she is not ready to stay with his parents and went away to her parental home and did not return back. Next one, it is his evidence that though elders have gone and advised her, she is not ready to listen to their advice. And all the attempts to take back his wife have failed. It is his evidence that first petitioner sent a notice to him. And he deposes that he is always ready to take care of the wife and children. But he is not ready to make a separate house and to look after them by making a house in Dharwad. Only the main reason is that she has to leave, the present respondent has to leave the Shubhok and settle in Dharwad.
Please tell the court that particular evidence which you are referring to, that the husband is not addicted to bad vices, is very good. Where did she say so?
He deposes that he is not addicted to any bad habits and he is not in a position to pay separate maintenance to his wife and daughter.
That is his statement.
Where
is the wise statement on that? Saying that he has no bad vices.
Next, my lord, he has got another witness. Next,
I saw that also.
RW2, and he deposes that he is the resident of a place where the respondent is also residing and he is attended to their marriage, and he deposes that the first petitioner after the marriage started harassing the respondent for making a separate house for her residence. And the respondent expressed his incapacity due to his father's illness. He deposes that the first petitioner was threatening the husband, claiming that she would leave his house and go away and would commit suicide, and the advice of the elders and family members to the first petitioner has not changed her. It is his evidence that even when they have gone to call the first petitioner, she has not agreed to join the respondent, but claimed that she would file a petition and claim maintenance before the court of law.
I think these proceedings are more or less like criminal proceedings, where beyond reasonable doubt everything has to be proved. No, very strangely, I observe these kind of orders only in Dharwad bench.
But to the
not in while sitting for 6 months in principal bench, we never see these kind of an inquiry under 125. What I could say is this order 7 rule 11 petitions in suits and 125 petitions are very different for this region. What is this inquiry by the the courts, what kind of an inquiry is this?
My humble submission is that.
No, there are differences between the parties. She is not in a position to stay with him.
Please, madam.
No competent court has held that she has deserted the husband. There are judgments of the Supreme Court to that effect. You can't. This is not the inquiry under 125.
No, I'm not sitting. I'm not going to encourage. The fact is that, my lord, only her intention is to make the house in Dharwad, but he's not.
That is his story.
Please, ma'am. That is her story, madam. Her only major intention is that he has to come and reside in
She says that she's been harassed. What is this criminal procedure? Maintenance and duty of the
In
husband.
this case also, my lords, only maintenance is awarded to the children, not awarded to the. In this case,
Because I can understand, like MMC for restitution of conjugal rights is allowed. Wife is not coming back to the husband, and she files a 125 proceedings. No, there is something on record to show that she has willfully deserted the husband. When there are disputes between the parties, wife may not hunt. Every husband has his own version for that. Wife has his own version for that. Prima facie, we have to look at it, not this kind of an inquiry.
Her only intention is that she has to make the house a residence, madam. Other than that,
Where did the wife say so?
Please, madam.
Where did the wife say
In the
so?
evidence will clear. She has cleared that.
Look at it. Look at it. That's why you point out that evidence.
Para number 16, my lord.
Para number?
16, my lord. Page number 20, my lord.
Yes.
Even otherwise, by looking to the evidence of PW1 itself, it is clear that she has hardly stayed for few months in the house of respondent.
That is the inference of the court.
That's one. In her evidence, she admitted, subsequent like.
What is she admitted?
She admits that her husband is doing only coolie work and not any other work. Therefore, it is suggested to her that husband has to incur huge medical expenses for father, for which she gives an evasive answer that the expenses for the hospital will not be every month but sparingly. When she admits that father-in-law is not keeping good health and suffering from due to his spinal cord, definitely he would need some medical attendant and medical assistance, which cannot be derived without spending money. So if her husband is doing fully work and has no other, definitely he would run short of money and he has to meet the medical expenses. Next one. In fact, the objection filed by the respondent in this question is that without any reasons, the wife petition has left the matrimonial home, and though he has taken proper care of her and gave much attention to her, she has left the house unnecessarily and staying away from the respondent.
The finding of the court. Where is this inference? What is this inference that is drawn?
Para number 19. In para number 19 also.
Read.
Though initially she has denied that she made a demand for a separate house, and that too to have a house in Dharwad, but in her cross-examination later on page number 4, her real intention has been brought out. It is suggested to her that if her husband makes a separate house whether she is ready to live with him, for which she gives an answer in the negative that she is too ready. She also discloses that she would go and stay with him only if he makes a house in Dharwad.
Art of the advocate in doing the cross-examination. Please come. The present the present petition is filed, agreed with the orders passed for criminal misdemeanors number 193 of 2021, dated 3rd February 2023, whereby the trial court, the court had dismissed the application filed by the wife seeking maintenance and allowed the application as far as the child is concerned and granted an amount of rupees 3,000 per month. The agreed thereby, the wife is before this court. Learned counsel appearing for the wife submits that the wife, because of the harassment meted out by the husband and in view of the differences between the parties and the fact that he is addicted to bad vices, has came back to her parents' house and started residing there along with the child. The trial court, the trial court had giving importance to the evidence of the husband, giving more importance to the evidence of the husband, and considering whatever is the case of the husband on its face value, has dismissed the claim of the wife, holding that without a reasonable cause, she is staying away from the matrimonial home. Learned counsel submits to the court as failed to consider that because of the harassment of the husband, she is staying away from the matrimonial home. The court had taken from the cross-examination, and basing on that, the court comes to the conclusion that wife wants a separate house at Dharwad and the husband, the father of the husband is suffering with, is having a, is a bedridden, and it's not possible for the husband to come, and that is, and basing on that, court has refused to grant maintenance to the wife. He submits that that cannot be the factor for the court to come to such conclusion. He submits that the wife who is not able to maintain herself and the husband who is an able-bodied person has every duty and obligation to maintain the wife. He had relied on the judgment of the apex court in case of Anju Garg and others versus Deepak Kumar Garg, reported in 2022 SEC Online SC 1314. He relied on para number
9 to 14, please.
He relied on para number
9 to 14.
9 to 14. Extract that he submits that the wife is entitled for maintenance, and as far as that aspect is concerned, that part of the order needs to be set aside. Next paragraph. When counsel appearing for the respondent, husband submits that the evidence on record clearly discloses that without a reasonable cause, she has left the matrimonial home and staying away from the husband. In the light of section 125(4) CRPC, she is not entitled for maintenance. He has drawn the attention of the court to the findings of the court, particularly where the court has particularly her admission that if the husband sets up a house at Dharwad, she is ready to join. Land counsel submits that it makes very clear that only for the reason that unless the husband sets up a house at Dharwad, she is not inclined to join the matrimonial home, which clearly shows that without a reasonable cause, she is staying away from the husband, and the court had rightly held that she is not entitled for maintenance. It is submitted that he is working as a coolie and taking care of his parents. Parents are only father. Parents, and it's not possible for him to set up a home. And as such,
there is a field, he is taking care of the field. There is a 4 acres of land, agricultural land.
And he is having agriculture land, and he is an agriculturist. It's not possible for him to set up a home at Dharwad. He just submitted that the wife is not entitled for maintenance. Court below had rightly dismissed the petition, and there are no grounds made out seeking interference to said order. Passed for the court. Next paragraph. Having heard the counsels on either side, produce a material not account. The section 125(4) no doubt contains a clause that section 125, before going into the merits of the matter, it is appropriate to look at section 125 of CRPC. Extract section 125. Section 125 4 postulates that, and it is appropriate to look at section 125 section 125 4. It says no wife shall be entitled to receive or the interim maintenance and expenses of proceedings as a case may be from her husband. Under this section, if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. When an application is filed under 125 CRPC, for various reasons, if the parties are residing separately, and no matrimonial cases are pending between the parties, unless and there is no finding by any other court that the wife without a sufficient cause is residing away from the matrimonial home, the court while considering an application under 125, basing on section 125(4), cannot do such a roving inquiry and give a finding as if it is a matrimonial case or a criminal case. The court has to prima facie look into the facts of the case. In this particular case, this is a case of the wife in her petition that the husband is addicted to bad verses and she was not taken proper care of. He has not bothered about the welfare of the child and the wife as such, and in view of the harassment, she was made to reside at the matrimonial home. Then husband had put forth his version about how he has been harassed, how the wife was not behaving in a manner, how the wife has to behave, or how a daughter-in-law has to be. In the cross-examination, when something was suggested to her, that if the husband comes to Dharwad, will she be willing to stay with him? For that, she gave an answer saying that she will reside with him. Taking a clue from that, the court starts observing that without a reasonable cause, only on the ground that the husband has to move to Dharwad, the wife is not staying with him within the matrimonial home, and without a reasonable cause, she's staying away, and the court disentitles the wife from claiming compensation. The inquiry that is done by the court, the particular facts and circumstances of the case is beyond the scope of section 125. In that view of the matter, this court is of the view that the wife is entitled for maintenance. Coming to the quantum of maintenance, there is no material before this court to decide the quantum. Hence, this court is passing the following order. 1. The order as far as the refusing the maintenance to wife is concerned is set aside, and the wife is entitled for maintenance. Number 2, regarding the quantum of maintenance, both the parties should file their respective statements of assets and liabilities as per the judgment of the Honorable Apex Court in Rajneesh versus Neha, and further within a period of 1 month from the date of receipt of the copy of the order, and both the parties are at liberty to adduce evidence, and basing on the same, the court shall pass appropriate orders within 4 months. Within 4 months from the date of from the date when the statement of assets and liabilities are filed by the parties.
In respect of petition number 2 is concerned, some enhancement.
What is on what basis?
Now she is for 4.5 years.
As far as the daughter is concerned, the concern as of now there is no material for this court to enhance the maintenance once after reading the evidence. If there is any other material, basing on that, the petitioner is at liberty to seek enhancement of maintenance to the daughter.
One more condition was, still today the present respondent is paying the maintenance to our daughter regularly.
Yes.
Earlier order may be. That order may be continued.
Why should be that it should be continued? It will continue, but the court has not interfered with that. Yes, next. 58.
Yeah, so matter has already been compromised before the trial court demands. We'll report the settlement demands.
Shall I record?
Please.
It is submitted that parties are. It is filed by whom?
Wife minutes.
It's filed by the wife, where her claim is rejected.
Please minutes.
It is submitted that the settle means the mutual consent divorce.
Please.
The matter is settled and the parties have obtained a mutual consent drivers in that view of the matter. Nothing survives for consideration in this petition, accordingly dismissed as unfunctions. Yes, next.
Number 60, article number 1,
$13,000 is awarded. And in the case of this driver,
What is his income?
30,000.
Wife and children or only wife?
Only wife.
Why you can't pay 13,000?
Instead of 30,000, I requested for 10,000.
Allowed salary more than 50,000 per month. More than 50,000.
Case of this driver.
Driver OTBT claim more than one third Supreme Court guidelines for one third of the salary.
We'll confirm this order. Unnecessarily, if again the court asks you to file your salary slip and all, then it's a problem.
Some leniency.
No, when you have the salary.
Pending the reasonings for awarding 13,000. Nothing more, just pending in page 20, para 14. Para 14. It is elicited in the cross-examination of respondent. Respondent has two other siblings, and that they two are working in employees of KSRTC and other organizations. Like the respondent J2
No, what will happen is the court can only say the reasoning is not correct, and if I have sent it, if the matter is again remanded back to the court, unnecessarily it is a burden for you and.
Therefore, I made a request for some leniency. That's all, not more than that.
Very reasonable.
Please come. Let's confirm this. Please come. Agreed with orders passed from criminal miscellaneous number 269 of 2021, dated 7 July 2023.
My request for remand.
Huh?
My request for remand.
Then in that case, I'll ask you to file your salary slip and decide it here itself. The dated 7 July 2023, whereby the court had granted maintenance of an amount of rupees 13,000 to the wife. The husband is before this court. Next para. Learned counsel appearing for the husband submits that husband is working as a driver in KSRTC and his salary per month is 30,000.
Yes.
30,000 and the court had granted 13,000. Learned counsel further submits that the court for granting an amount of rupees 13,000 as maintenance, there is no reasons are forthcoming in the order. Learned counsel has drawn the attention of the court to para 14 of the order and submits that the court, the reasoning that is given is that the respondent has two other siblings and they are also working as employees in KSRTC and other organizations. Like the respondent, they are too responsible for to look after their mother. But this is a mother.
Yes. No, wife.
What is this like the respondent? They are
I took up the constitution that I have to look after my mother.
The petitioner, for the reasons best known to her, that is petitioner's wife, for the reasons best known to her, adduced no document to prove the additional income of the husband besides his monthly salary from KSRTC. Therefore, the court had granted 13,000 and counsel submits that absolutely there is no reasoning in the order and the order is liable to be set aside. Next para. Learned counsel appearing for the respondent wife submits that in fact is earning salary of an amount of rupees 50,000, but it's stated before the court as 30,000. Even if 30,000 is taken as salary, still the court had granted only an amount of rupees 13,000, which is reasonable. He submits that the husband is bound to maintain the wife, and the court had rightly granted the maintenance. Next part. Having heard the counsels on either side, per material on record, she filed the petition seeking maintenance of an amount of rupees 25,000. the undisputed facts in this case are that husband is working as a driver in KSRTC, and his contention is that he has to take care of the mother. Court has given a finding that already other two children, other two siblings of the husband are also employed, and it cannot be believed that he alone has to take the responsibility of the wife, of the mother. That apart, when his salary is 30,000, granting of an amount of rupees 13,000 towards maintenance of the wife, this court finds no reasons to interfere. It is not even the case of the husband that the wife is earning and she is not entitled for maintenance. Hence, viewed from any angle, the order of the court is absolutely legal and requires no interference from this court. Accordingly dismissed. Next.
Just one aspect that husband petitioner has not produced single document in our record.
He has
Not
not
produced single document. He has let evidence, not produced any documents.
The husband, in the order, the court has observed that for the reasons best known to him, he has not produced any document in support of his income. However, he has not produced any evidence.
He has let evidence,
He has
but not
not
produced
evidence.
any documents. Please.
Yes, yes.
Number 16. Public promotion director.
Wherein challenging the maintenance of for the trial. For the wife, your lordship, insofar as respondent number 1, respondent number 1, your lordship, 10,000 maintenance has been awarded. And with respect to your petition number 2, son, 8,000 has been awarded. Considering that she is unable to maintain herself, your lordship.
So total is 18,000.
Please, your lordship. Total is 18,000, your lordship.
You are for the husband.
Please, your lordship.
What is your income?
Please, he is working as a ARF, your lordship.
Working as a?
ARF, additional regional forest officer.
What is your income?
His salary is 62,000.
And then what
That is the gross salary. Difficulty is, your lordship, she is also earning. She is running the beauty parlor as well as the whole.
Where is the evidence for that?
In this matter, she has denied the suggestion, your lordship. However, in the matrimonial case, divorce petition filed by the husband, then she has admitted that she is already running the beauty parlor, that is a L'Oreal salon, as well as she is owing the hotel. Also, she admitted that she is owing 7 acres of land.
Where is that order?
But if lordship permits tomorrow, along with the memo, both the documents I'll produce.
In this case, my lordship, petition was filed in the year 2016, my lordship. Order was passed on, my lordship, in the year 2023. Till today, my lordship, the arrears is, my lordship, as per my calculation, 16,92,000 rupees, my lordship.
And it stays there?
Stays there, subject to deposit of certain amount, my lordship.
I'll verify that has been deposited in the trial court, your lordship. Instead of your lordship,
We'll list this matter on 13.
Please.
By the time you have to place before this court a calculation memo,
Please.
what are the amounts that are paid by you? Number 1. Number 2, file that memo with concerned pass order. List this matter on 13. By the time the counsel for the petition should place before this court the calculation memo showing what are the amounts that are paid to the wife from the date of petition till now. Full stop. The petition shall also place before this court the order, the evidence of the wife in the matrimonial proceedings. Is this that MC is disposed of?
MC is disposed of, or the same was challenged before this honorable. There's a conditional interim order stating that we have to deposit 60,000, your lordship. Instead of depositing in this matter.
On that you can tell the court by list on 13. The amount in the before matter, disposed matter, the amount that is amount in deposit by the husband shall be transferred to the court below. Yes.
In our matter, interim
order is extended till the next date of hearing. Yes, next.
Number 16. Very good.
Yes, where is your seat? Give the next matter. Next matter. Yes, what is it?
and simply transferred from Hubli to Bangalore because he was represent.
No, you were saying that the wife is working in Bangalore.
Please,
What did you file?
Where is the affidavit?
Have you filed your objections to this?
No, copy not that.
Give him a copy.
Please, without court action, I can't do because of that.
In CP number 100236 of 2024, when counsel the petitioner shall serve a copy of the petition on the counsel of the respondent, and the respondent shall file his objections. List this matter on 20th. You have 2 weeks time. Yes. Intermodal is there. Intermodal in 62 is extended to the next date of hearing. Yes. Yes.
Number 60.
Therefore, respondent.
Husband.
You appear for the?
Husband.
No, you said respondent.
I appear for the respondent.
No, I thought you were still in the other case. You are stuck here. Yes.
Filing the revision petition against author of the trial court.
You are for the wife.
Husband.
How much is the amount granted?
12,000 has been granted.
What is your income?
I'm an agriculturist, having the area nearly up to 13 acres, 17 acres, wherein the partition has been filed by the sisters against my father, mother, and myself, mother. And now, in the last occasion, we have given proposal that to extend my share will be 3.19 guntas, 19 acres. Now I have suggested 2 acres may be proposal, but they didn't agree with the last occasion, which is the mediation is with us.
The mediation, what has happened is the husband didn't agree to give a single penny to her.
Now,
and now
he should have.
Now they are giving
He should have something to give you, isn't it?
Please, yours.
So first of all, you have to tell the court what is that he is having.
Please. He is owning 25 acres of land.
Is the 25 acres is owned by him?
Owned by
or is this a joint family? Problem with you is you don't listen to the court. 25 acres is his own land or it's a joint family property?
He is the only son.
Huh?
He is the only son.
He's saying that he has sisters and the suit is filed.
He has one sister. She has filed a petition, but it's a colluding suit.
My daughter is not entitled for.
She is entitled, but the suit is not going further.
How much is the land?
And that's one of only 2 house properties.
17 acres and not guntas. 17 acres, 18 guntas.
Then why you will get only 3.5?
There are 6 members.
How 6 members? He says you only one sister.
I'm permitted to produce a plain copy before the court, wherein my sister has filed a partition against us.
No, basing on what you are saying that it is only one sister.
Because I have seen the plaint of the OS, which has been filed, wherein she states that she is the sister. She is the sister, and she has made a.
How many are the parties?
She has made 5 parties.
So that means three children are there.
But my prayer to your Lordship is that the order passed by the trial court is of dated 2 August 2023, and the order was that the maintenance has been granted from the date of filing of petition. There is the arrears of 3,48,000, and till today he has paid only 50,000 rupees. She has 2 daughters. For one, Ritvik Reddy, age is of 8 years, and Kirti Reddy, 6 years old. From past 2000, from here,
Stays there.
Stays
there. Where is the condition? What is the condition?
Condition is that
from 2018 they have been separated.
6/6/2024 is the order.
Except 50,000, they have not paid any amount.
Let him clear the arrears.
Then counts for the petition submits that out of the arrears of 1 lakh, the petition has already paid 30,000, is ready to willing to pay additional amount of 50,000 within a week. Submission is taken so accordingly you paid 50,000.
We have paid 15,000 on 28/6/2024.
So 30,000, 50,000. You paid 80,000 as of now. How many are the arrears at that rate?
After deduction also, it's 3,48,000.
Pay another 50,000, we'll hear the matter. But list this matter on 2nd of December. 2nd of December, by the time the petitioner shall pay another sum of rupees 50,000 to the respondents, or else the stay granted by this court stands vacated. Interim order earlier granted is extended till that. Yes, next.
For respondent, another connected matter, which is filed by the wife seeking announcements.
It's also there.
You have to comply that. In the meantime, we will directly to take notice or comply.
What is this non-complaints of officers?
You have to comply the office of
who is the advocate? There are two names are there.
In the second petition,
No. In 64, two advocates' names are appearing. Three advocates, I think, names are appearing. Who filed the wakalat? Whose name is there? Look at it. What is the main name? Who is the first advocate? Mr. B.J. Krishna is directed to take notice on behalf of the respondents in RPFC number 1001110 of 2024, and the land counsel for the petition shall serve a copy of the same on the council. He shall in RPFC number 1001110 of 2024, the petition shall comply with the office objections by 14th of November. This is matter on 20th. Yes, next.
In the first matter, filed IAC for withdrawal of amount in deposit. It seems 2,20,000.
Is there? Yes, IA number. IA1 of 24 is filed, seeking to withdraw the amount deposited by the petitioner husband. IA is allowed. There is no representation on behalf of the petitioner. IA is allowed. There is no representation on behalf of the husband. IA is allowed, and the respondent wife is at liberty to withdraw the amount deposited by the petitioner husband. Yes, next.
Number 66.
No representation for dismissal. Tomorrow.
Number 67. Malicious making.
Grant of maintenance of rupees 8,000 to the wife and 4,000 to the daughter.
Which matter?
67.
67 can't be interim maintenance, it is RPFC. So it must be a final line. Let's see.
Sorry, final. 8,000 to the wife and 4,000 to the daughter.
8,000 to the wife and 4,000 to the daughter.
One minor son is with me, my lords, and mother. And my lords, my father has also filed a maintenance petition which is pending.
Against you?
Please. And my lords, while avoiding that, my lords, the trial court has not considered. Even in cross-examination, she has admitted that, my lords.
What is your income?
Income is, my lords, the trial court comes to the conclusion I am earning 14,700 getting pension.
How much you are earning?
14,700.
If you are earning 14,700, how can there be maintenance to 80,000?
My lords, may kindly see para 11 of the order. Para 15, page 25.
Para 15.
Please. So on where.
Free.
So, on perusal of the above, it is noted that petitioner being legally wedded wife of the respondent and having two children out of the wedlock, and because the relationship the respondent husband is duty to bound maintain his wife and children and on perusal of assets and liabilities of the petitioner and the respondent, it is to be noted that petitioner wife having studied up to second PUC and being a housewife, while on the other hand, the respondent being a retired from the army in the year 2020 and receiving a pension of rupees 14,700 as per his assets and liability and statement, but not having produced any document.
Where is the evidence?
Your Lordship, one thing, Your Lordship, this Honorable Court had granted stay with the condition that monthly 8,000 maintenance has to be given and also 1,50,000 has to be deposited. They have deposited 1,50,000, Your Lordship. Up to now, not a single penny have been received for, as per this Honorable Court's order.
How much it comes to?
Your Lordship, 8,000, the Honorable Court had ordered 8,000 rupees per month, Your Lordship.
From May,
So, from?
May 2024.
You have cleared.
June, July,
so how much you have to pay? June, July, August, September, October, November. 6 months.
My Lord, and they have
I will post this matter on
my Lord, sir,
20th.
Now, my Lord, sir, it is posted for before the trial court for they have
whatever it is, as per the order of the court, you have to pay from May to November 8,000. That is 6 months. 48,000. You pay that amount. That is around about 50,000 by
May, June, July, August, September, October, and November.
7 months.
7 months.
It will be more.
Later on, may not say that I have
56,000 then.
It comes to 56.
As per the order passed by this court, the petitioner has to pay the arrears at 8,000 from May to November. That said amount shall be deposited by 21st of November, or else the petition, the stay granted by this court stands vacated. List this matter on 25th.
Small submission may be permitted to withdraw the amount, sir.
On such deposit, on such.
1 lakh already deposited 1,50,000.
Any IA file?
No.
The amount, next paragraph, the amount already deposited by the husband as per the orders passed by this court, an amount of rupees 1 lakh.
50,000.
1,50,000. The wife is at liberty to withdraw. Yes. Date is already given. What is the date I said? 25th. You have to pay the money by 21st. And the matter will be listed on 25th. By that time, if you have not paid, they will vacate the stay. Yes.
Petitioner is the wife of seeking transfer of the petition from Gangavati Court to Shirgupa, Ballari district, my lord.
Where is the counsel for the respondent? Counsel for the petition is present. No representation for the respondent. List is matter tomorrow as part. Yes, next.
I wait for the petitioner in this case. Division petition is filed against me, challenging IA and seeking for the stay, Your Lordship. SPD data. Already decided in OS and FDP proceedings is going on. They have filed the...
No, let's look at the interim order, impugned order.
Please, I agree with interim orders.
Let's look at
order dated 22/20.
What is the suit for?
Suit for partition and separation. Permanent injunction. OS is filed and
Suit for notice of declaration by way of adverse position.
Is it so? Which is correct now?
OS is already decided and FDP proceedings is going on.
No. What is the present suit?
Present suit is for declaration and possession.
That's what I'm asking. What is the present suit? Present suit for declaration. Please come to your application under order 7 to 11.
Please. IA is.
Where is that?
My friend has not furnished, even I am not giving a copy of that. IA as well as plaint.
No, without filing an IA, how they have numbered it?
But I have to not say what my document. Today I am getting the document plaint.
Yesterday entire file was given, he himself has taken that.
In the entire file, where is the IA? IA for your, without IA, how it will be numbered?
IA number 2 is
not IA before this court. Now, whatever is they have questioned the impugned order, they have to file the IA that is filed before the trial court and the counter or objections filed to that. Without two, they can't number this CRP. Where is it?
Plaint, IA and objections are.
Where are they?
Earlier it was filed a writ petition, Your Lordship, annexures was made. Then annexure in the writ petition, all the documents.
File all the documents, without that we can't proceed.
Please.
This
A
is
date may
matter,
be fixed, Your Lordship, I'll file entire.
this is matter on 20th.
Please.
By the time, the
At least.
petitioner shall file all the relevant documents.
Please.
Yes.
Okay. Seal number 7. Number 30 sofa.
Assist for 1 week time. Assist for 1 week time.
Why?
Get some instruction.
Interim order is there?
No.
At the request of land counsel, the respondent, this is matter on 21st,
22nd.
22nd.
Because 23 trial court it is there.
22nd. Seal number 7, 8 point.
Seventeen?
71.
Plaintiff's reason filed suit for eviction. Small cause suit for eviction was filed. Suit property is a commercial property more than 15 square meters. And the suit was filed at the time of evidence of being recorded. The respondent files an application under 7-11 stating that this property is covered under the Karnataka Rent Act.
Karnataka Rent Act.
Rent Act. That is how suit is not maintained. The Honorable Trial Court has applied that and held that I have to file a petition under Rent Act, not the small cause suit is maintained. Based on that, I am in position. The Lordship is pleased to peruse the Rent Act. More than 18 square meters commercial property is excluded from Rent Act.
Order 7, Rule 11 is allowed.
Allowed. And that too, when matter was being set up for evidence, cross-examination, part of the evidence was over. And as far as my plaint is concerned, I specifically avoid in my plaint that this is more than 14 square meters, commercially done, and all these things. Based on, they say that they have led evidence and are not told that there is no commercial property and other things. They specifically, even in the written statement, admit that they reside there and also run the garage.
Against such a revision lies.
Pardon?
Against such a revision lies.
Yes. Against the allowing of that application of 7-11. I have put this on the court in this case. I need not go for the Rent Act because that is excluded. Lordship is pleased to peruse. Commercial property more than 14 square meters is excluded from Rent Act. See the 2013 suit for small cause. And at trial end of the evidence stage, they come up with this application and states that there is no commercial. In written statement also they admit to certain extent.
Then please take, will issue notice to the respondents and see. Issue notice to the respondents so that we can decide. The list is matter on 2nd of December. Yes.
Seal number 17.
Please, Madam, I give for petitioners in this matter.
Yes.
The petitioner has filed his petition being argued for rejection of application under Order 7-11 manner. A.L. Suit is not to partition and separate possession. Without any cause of action is allowed.
Please straight away come to your IA.
Please. It is at page number 40 to 48 minutes. 40 to 48. I have filed a typed copy number, which is at 40, page number 45.
Now, what are all the grounds which you have raised in this Order 7 Rule 11? Can it be considered by the court You say there is no cause of action, it is not a joint family property, it is a self-acquired property. Where from the court will decide all that?
There is no cause of action is seen from the.
That's
plaint.
your case.
Please.
He has set out a cause of action saying that it is a joint family property. He says it's a joint family property. You say it is not a joint family property. How it is not a joint family property? For that you have to adduce evidence. Court has to look at your written statement and the evidence adduced by you. So can that be decided in petition and order 7 rule 11?
That's my only contention is that there is no cause of action because the cause of action shown in the plaint by the arguments in the plaint itself, it clearly shows that it's an
Please come to the plaint.
Please, my lord.
We'll understand what you're saying.
Please, my lord. At page number 18, my lord. If I can read para 3, my lords. The plaintiff defendant number 1 and their late brothers by name Venkappa and so and so.
What he says is cause of action.
Please.
Cause of action for the suit arose on 15/7/2022 when plaintiff asked the defendants for effecting partition to allot the legitimate 1/4 share. He refused for the same. He has made out a case.
But he has admitted there was partition in the year 1990 and my lord, all the properties were divided among his brothers.
Let's see what is that you want to read.
Please, madam. At para 3, my lord. And all the sons of Irappa Malay were the members of the undivided family and the suit property along with other properties of the family were joint family ancestors undivided properties of the family of plaintiff and defendant. Plaintiff and his brothers, according to their convenience, got family properties divided and also got equal share. But unfortunately, plaintiff was not given with any share in the suit schedule A property. In fact, the plaintiff is also entitled to 1/4 share in the suit schedule A property. At the time of effecting order partition, a vardi was submitted to the revenue.
What else you want? According to him, he is entitled. It's not given.
But it is in the record in the year 1990.
Let it be.
There cannot be ignorance for 32 years. There cannot be ignorance for 32 years.
So how it will be decided?
No, but his only contention is that his name is not located along with other brothers. The remedy is elsewhere.
No. Your remedy is elsewhere, not in order 7 rule 11. Agreed with the. You want to withdraw or shall I dismiss it?
I'll take it.
Tomorrow?
Yes.
Yes, next.
Number 73.
Wife switch
From where to where?
from Hukkeri to Belagavi family post.
From?
Hukkeri to Belagavi,
Distance?
60 kilometers.
When is this petition filed, MC?
MC, my lord, 2023.
What is the stage of it now? Those are all the factors which you need to tell the court. Does this matter when? When? Tomorrow, by the time the turn comes for the petitioner, shall place before the court what is the stage of the proceedings in the MC.
Please.
Yes, next.
Number 74. Anantarpadi.
Yes.
Vice President is seeking transfer from Gadag to Gopal.
MC is of which year?
60 kilometers.
MC of which year?
64, 98 of 2024. Filed by the respondent pending on the file of Principal Judge Family Court Gadag.
When was it filed?
It's on 15/6/2024.
Any other case pending at?
Yes, ma'am. The present petition is by the DV Act against the respondent.
Section 12 petition is pending.
Which is
Please come.
DV Act means criminal misdemeanor
Agreed with
408
orders
of-
passed in. The present petition is filed, seeking transfer of MC number 98 of 2024, pending on the files of Principal Judge Family Court Gadag to the Principal Judge Family Court Gopal. The brief facts of the case are: the marriage was organized on 24/11/2019 at Bhagyanagar, Gopal. In view of the differences between the parties, on 13/7/2022, the wife had filed the petition, the Domestic Violence Act, and the same is numbered as criminal miscellaneous number 408 of 2022 on the file of the civil judge at JMFC open. Thereafter, on 14/7, notice was issued, not 14/7, notice was issued to the husband in the said case. Thereafter, husband, that is a respondent herein, has filed a petition under Section 9 of the Hindu Marriage Act seeking restitution of conjugal rights in MC number 98 of 2024 on the file of the Principal Judge, Family Court, Gadak. In that, the petitioner had received notices on 15/6/2024. Thereafter, the present transfer petition is filed. It is a case of the wife that the distance between both the places is 60 kilometers, and it's very difficult for the wife to travel 60 to 70 kilometers, and it's very difficult for her to travel, and also and also as she is not financially independent. It is a case that she has been depending upon her parents. And the matter may be transferred from so and so to so and so. Though notice is served on the respondent, no vakalat is filed on his behalf, having heard the counsel the petitioner. There is a material on record, considering the fact that the distance between so and so and so and so is 50 kilometers, is between 50 to 70 kilometers, and as a wife is not in a position to travel on her own, and also not having the financial capacity. Further, considering the inconvenience caused to the wife, this court is passing the following order: so and so is withdrawn and transferred to so and so. Now, the reason, sir, that criminal misdemeanors is also pending. Yes, next.
Number 79, Kazi.
Where is this counsel for the respondent? Heard the counsel for the petition in part. No representation for the respondent. List this matter as part for tomorrow. Yes, next. Wednesday. Next Wednesday. Inter-alia granted is extended till then. Next 76. How much is granted?
4,000 is not granted.
Huh?
4,000 per month. That's not a matter yet. The relationship involved in this case also is your facts are announced.
This is the mic, I'm not able to hear.
Sorry. Lord, admittedly, my lords, it is a second marriage for the Lord respondent to area. See, my lord, file my lord 125 proceedings stating that my lords, Lord, C and my lord, her son, my lords, are the Lord wife and son of the present petitioner.
You are denying the relationship.
We are denying the relation of the my lord petitioner number 2, son. That is admitted by the my lord petitioner number 1 before the trial court. Just discharged. It is admitted and the my lord considered and my lords, it is dismissed against the petitioner number 1. And against the petitioner number 2, my lord, the 4,000 is granted. Wherein, my lords, my lord, her marriage of the first marriage is still subsisted. During the subsistence of the first marriage, she entered my lord second marriage with the my lord present petitioner. And therefore, my lord, it is not a my lord legally wedded wife. She is not a legally wedded wife of the petitioner. And my lord, one more
stay
thing,
together with her, there is no problem.
And my lord, one more thing, my lords, in another proceedings, my lords, she herself admitted in the evidence that my lords, she has my lord 10 lakh rupees deposited in her bank account, and also she has a landed properties in her name. In the present proceedings only it is.
This comes for the petitioner submits that admittedly she is not a legally wedded wife, and in other proceedings she has admitted that she is having her own income, and also she is having 10 lakh rupees.
10 lakh rupees in landed properties.
10 lakh rupees
in her
in landed properties. The court, without any basis, has granted maintenance of an amount of rupees 4,000. Considering the same, they shall be stay of all further proceedings in so and so, till the next date of hearing.
Much obliged.
Ministry is directed to issue notice.
Much obliged.
Yes, next.
Number 77. Dismissal. Take for
Your Lordship, I am for petitioner.
I request for a week's time to take an instruction and to file for segment of objection.
Is this matter
Your Lordship, this is a transfer.
is coming up for the first time?
No, this is third time.
You have an interim order?
Yes, sir.
List this matter on 14th of November. By that time, the respondent shall file his objections, or else the matter will be heard on merits.
Please.
Yes.
number 17.
Vice President, seeking transfer of the municipality from Hubli Court to Shillong Court. From Hubli Court to Shillong Court, my lord.
What is that? Hubli to?
Hubli to Shillong.
What is the distance?
70 kilometers, my lord. And my lord, wife has filed a first, she has filed a first petition, my lord, the Shillong Court, my lord. Thereafter, he has filed.
What she has filed there?
She has filed for divorce.
He filed for restitution.
Please, my lord. And she is staying in Calcutta village, my lord. From Calcutta village to Hubli, it is almost 70 kilometers, my lord. And from,
Yes. Who filed first?
The petition is pending before the principal family court, Your Lordship. Now the wife petition is pending before senior civil judge, Your Lordship.
So your case is before a better court. Your case is before a better court.
No, this is the principal family court, Your Lordship.
So what?
Your Lordship,
Will transfer it.
So there is
Any other reason? Any other grounds you have?
and 70 there is a direct bus available.
You go in the same direct bus. Anyway, you have to go to the court for attending restitution of divorce petition. You will appear in this case also that time. Anyway, both will come in now, both matters will come before the same court.
Fixed date for disposal. This fixed date was
Which year is the MC?
24 years.
Court has lot of work to do than disposing your MC of 24. The present petition is filed, seeking transfer of MC number 293 of 2024 on the file of the principal family court at Hubli to the court of the senior civil judge at JMFC at, or how was it spelled? Shiggaon.
Shillong, my lord.
Shiggaon.
Shillong.
JMFC at Shiggaon. The facts of the case are the marriage between the petitioner and the respondent was solemnized at Hubli on 11/5/2013. In the light of the differences between the parties, on 19/6/2024, the wife had filed MC number 48 of 2024 under section 13(1) of the Hindu Marriage Act, seeking divorce on the file of the senior civil judge at JMFC at Shiggaon. Thereafter, on 3/7/2024, husband had filed MC number 293 of 2024 for 2024 on the file of the principal family court, Hubli, under section 9 of the Hindu Marriage Act. It is submitted that the wife is residing in a village and traveling to the place where the MC filed by the husband. It is 70 kilometers distance and is difficult for the wife to travel. Like counsel submits that as already the MC filed by the wife seeking restitution of conjugal rights, divorce is pending. If that is also transferred to the same court, it would be in the interest of both the parties. Next para. Land counsel appearing for the respondent husband submits that his case is pending in a family court, principal family court, and further 70 kilometers is not a big distance. The wife can travel, and no grounds are made out for transfer of the case from so and so to so and so. Having heard the land counsel on either side, there is a material on record. There is no dispute about the fact that the wife had first filed the MC number so and so, seeking restitution of conjugal rights. Seeking divorce. Thereafter, husband has filed the MC, seeking restitution of conjugal rights, both on the ground of convenience of the wife and also to see that there is no conflict of conflicting judgments. It is all the more necessary that the MC that is filed by the wife, filed by the husband, pending on the file of the so and so, shall be transferred to the court of so and so. In that view of the matter, this court is passing the following order. The MC number so-and-so pending on the file of so-and-so is withdrawn and transferred to so-and-so. Accordingly allowed.
Bill number 79, other gentleman, sincerely.
Yes.
79.
This is what it is.
Heard the counsel for the petitioner, no representation for the respondent.
No, respondent,
You appear. Oh, same, yes.
kindly act tomorrow, because
Why?
the evidence is,
Evidence comments.
yes, sir, yes.
Huh?
Evidence is coming.
Not yet coming.
But I verified my submission.
Tomorrow,
Yes, sir.
then counsel for the respondent shall get instructions. Tomorrow, instructions by tomorrow with regard to the status of the case.
Yes, sir.
Huh?
Kindly come Monday.
Monday. Yes, please.
No, it's white petition, Malak, seeking transfer from Dharwad to Bhopal.
When is Mr. Srikanth?
Srikanth.
Heard the counsel for the petitioner in part. No representation for the respondent. List this matter tomorrow. Next.
Malak, same.
Interim order granted is extended till then. 81.
White not seeking transfer from Lakshmineshwar Court to Procedural.
Distance.
What?
Distance.
131 kilometers.
MC of which year?
24 years. On 8
The present petition is filed seeking transfer of MC number 57 of 2024 pending on the file of the senior civil judge and JMFC Lakshmeshwar and transfer the same to the Honorable Principal Senior Civil Judge. Where? Housepet. It is submitted by the council that the distance between the place where the petitioner is residing and where the court is situated is about 131 kilometers. 131 kilometers, it's very difficult for the wife to travel. Considering the same, they shall stay of all further proceedings on the file of so-and-so till the next date of hearing. The petitioner is permitted to take out hand summons on the counsel appearing before the trial court for the respondent and file a memo to that effect by 22nd of November. List this matter on 25th.
Please.
Next. Distance. MC is of which year? Huh? 24. The present petition is filed seeking transfer of MC number transfer of MC number 3 of 2024 on the file of the principal family court at Kalburgi and transfer the same to the senior civil judge and JMFC Putligi. Then council submits that the distance between both the places is 350 kilometers, and it's very difficult for the wife to travel considering the same. There shall be stay of all and hand summons same dates. What were the dates given? by 21st. You should find a memo, and the matter will come up on 25th. 22nd and 25th. 22nd. 25th. Next.
And for the petitioner husband, I have filed a matrimonial claim for restitution of conjugal rights. As notice was served to the respondent wife, but she did not appear and she did not pursue the case. And an ex parte order was passed against the wife. And in return, the respondent wife approached this honorable court and remanded this honorable court was pleased to remand the case back to the family court. And there was a condition that it has to be completed disposed of within 6 months. But instead of pursuing the MC case, the respondent wife has gone ahead and filed under section 125 a maintenance case in criminal misdemeanors. Now, she is not responding to the MC case, and it is a criminal misdemeanors. An award of 8,000 rupees has been given as an interim maintenance to the wife. Whereas she is a working woman,
Let's see that, let's see that.
Yeah.
How much is the amount granted?
8,000 rupees.
What is your income?
As of now, it is nil months. April 2022, I have been relieved from my services for us. From HSBC Bank. I was working for HSBC Bank.
Why you are relieved?
I was not my health problem.
What is your age?
Which is around
Pay 4,000.
no, that's less. As of now, the date of petition,
That would be from the date of petition.
yes, sir. 23, November 20.
Some amount to deposit, otherwise there can't be any stay.
20,000. 20,000.
50,000. The
50,000 will be too much.
then how much it will be? Petition submits that the respondent is a working woman and the petitioner has lost his job. In spite of the same court had granted 8,000 per month as maintenance, considering the
And that
submission.
also is an ex parte order.
Considering the submission of the done counsel, they shall stay of all further proceedings on the condition that the husband shall deposit an amount of rupees 25,000 within 8 weeks from the date of receipt of the copy of the order. Petition is permitted to take court hand summons of the counsel appearing for the respondent for the trial court and shall file a memo to that effect. This matter on 18th of December. Yes, next.
Number 84.
This petition filed by petitioner, approved by the informed order of line number 3.
Your wife or husband?
Miscellaneous.
Your wife or husband?
I'm husband.
How much is granted to the wife?
20,000 is granted. But I was residing at that time in UAE, Dubai, without giving the fair opportunity to me and
what is your income according to you? What is your income?
25,000.
20?
25,000.
Deposit 10,000.
One interim application is there. I'm ready to, from the date of the order, that is 5/11/23, 16/11/23. I'm ready to deposit half the amount. The interim application, stay after.
Where is that?
It is there in Can you stay the proceedings?
Court will stay the proceedings. You are saying there's something you have stated. Where you have stated?
Is not there.
So
Without
you are
the-
ready to pay 10,000. That's what you're saying. 20 is granted. 50% is 10,000.
I'll tell you. When the case is filed on the 13/10/23 and 16/10/23, after 3 days of that, application is filed by interim maintenance under section 13 of FCI Act. And on next day of 17, without producing any document, without considering my...
No, you yourself were saying just now that you are ready to pay 10,000 right from 10th month of 2023.
No, half of the amount.
Half of the amount. Half of the amount is 10,000. Court has granted 20,000. That is 10,000. That's what I'm saying. So from there to now, it is 13 months. 13 into 10. It would be 1,30,000.
From the date of the order of that court.
So we'll say, without going into all that, You are ready to deposit 1,30,000 within a period of 8 weeks, and you will continue to pay 10,000 by 5th of every succeeding month. So for the times to come.
Yes. Yes.
You understood? The non-counsel for the petitioner submits that the court without any basis had granted maintenance of an amount of rupees
Further,
20,000.
20,000 is there after disposal of this.
It is submitted that the court without any basis had granted maintenance of an amount of 20,000. He submits that the petitioner income itself is 20,000. 25,000 and the court had granted 20,000. Considering the same, there shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 1,30,000 by within 8 weeks from the date of receipt of the copy of the order. If he fails to deposit the same, the stay granted by this court stands vacated. Yes, notice to the this is a pending one. Petition is permitted to take out notice on the counsel appearing for the hand summons on the counsel appearing for the respondent for the trial court, and shall file a memo to that effect by 3rd of December. List this matter on 10th of December. Yes.
I'm arguing for petition matter and toxic counsel matter. The counsel is not speaking. Kindly I recommend the matter.
Place this matter on 13th November at the request of front counsel for the petitioner. Yes, next. Tomorrow, all these part-heard matters, let them come on the top of the list. Because already heard matters, why are they coming in the bottom? No, we'll continue. We'll continue. Yes. Yes.
Today I argued the matter. My lord was pleased to ask when he
resigned.
Kindly see the page 26.
Page number
26. That also I submitted, he lordship. Thereafter, if he lordship asked the other side, he tried to produce some document that just states his copies don't remain. Page 26.
During July 2019, the respondent came to India on 9 days leave. So when is this petition filed? This is filed in 2021. And
30th August 2021, it's filed.
30th August
2021.
It's filed. And according to you, you lost your job when?
January 21.
January 21. By the time it is filed, you have already lost your job.
Yes. Because of the harassment by the respondent wife only.
How much is granted by the court?
10,000 is the interim maintenance is awarded.
So please come to the order.
Yes.
Let us see what is the finding of the court on your.
Regard to the submission, madam.
You have given papers
Yes,
to you
yes,
also.
yes.
Take that.
They are all MC proceedings. MFA is filed before this on the court challenging those.
No. First, what we do is
Yes,
we'll read this order.
Yes, 33.
And then we will go to
Yes,
the.
33. Yes, 33. There is no finding with regard to source of income of the petitioner. Include order. Yes, 33.
Para
8. It is not the case of the respondent husband that the petitioner is earning, nor does the dispute the relationship between the himself and the petitioner. Admitted the petitioner has been living separately for the last 4 years. That the respondent husband admittedly being an engineer graduate in civil as jobless. The averment of the statement of objection do indicate that the parents of the respondent husband having their own property. The respondent husband being a qualified civil engineer and the petitioner wife being a postgraduate with a B.Ed course, the petitioner wife, in the opinion of this court, is entitled to lead her life after her marriage in a dignified manner. Therefore, it is most appropriate to call upon the respondent husband to pay the monthly maintenance of rupees 10,000 rupees monthly maintenance from the date of petition, as admittedly the parties hereto have been living separately for the last 4 years. With these observations, while answering the point number 1 partly in the affirmative.
Now let's see the papers which he is passing on.
Yes. Just putting the judgment in the NFA, the MC. She filed the restriction of conjugal rights. It is only to overcome the allegation.
No.
In fact,
No,
Let's see, what's the finding? What is that you're relying on?
my lord,
no document with regard to source of income of the petitioner.
Let's see, what is that you want to see?
that's what, my lord.
Oh.
This is totally understood looking at the entire facts and circumstances of the case, my lord. I am from Adoni, he is from Hospital, got married. That is admitted, my lord. Subsequently, parents of the wife believed that son-in-law will be there in Bangalore as engineer, working in JWC. Subsequently, he left his wife in hospital.
Now please understand, for this application, all those things are not necessary. In this particular MC judgment, you're relying on something. Please tell the court, we will look at it.
Please, my lord. In spite of my repeated requests, respondent husband has not allowed her either to take away to abroad or to have residence in hospital with his parents. And while working in Bangalore also he didn't take away. So that's why ultimately she filed one maintenance section and 125 CRPs. That was allowed. Subsequently, he transferred all the earnings while he was abroad to the accounts of his parents and his brother. And they purchased a lot of properties in their wives and in-laws' land. And finally, he is making an allegation that because of the desertion up to 4 years, because no one treated her properly while she was there with him, with them. She is always longing to go with him. But parents, they ill-treated her, harassed her mentally, physically, in everything. Subsequently, she filed criminal petitions also. And finally, she requested you, your lordship may kindly, in page number 10, my lord. Para number 4, my lord. I am reading his own averments, my lord. Per contra, the respondent husband is verified counter dated 15/3/2022 not only opposed petition filed under section 9 of Hindu Marriage Act by the petitioner, but also seeks the relief of divorce based on the grounds of cruelty and desertion as a matter of counterclaim. Next, my lord. There is a link, my lord. Thus, the respondent in his verified counter is failed enough to admit his marriage relationship with the petitioner. The other averments, which amounts to allegations against respondent and his family members, are denied as false and baseless. Further, my lord, in page number 15, my lord, para number 10, my lord, looking at these rival pleadings between the parties, court has formed certain points for consideration. The first one, my lord, does the petitioner for the reasons assigned in her petition prove and establish that the respondent by neglecting the petitioner has withdrawn himself from her company without lawful excuse? It is answered in affirmative, my lord. Does the respondent husband for the reasons assigned in his verified counter prove and establish that the petitioner wife caused him to agree in terms of section 13 class 1 1A of Hindu Marriage Act? It is in negative, my lord. Next one is, does the respondent for the reasons assigned in his verified counter prove and establish that the petitioner has deserted him in terms of section 13(1)(1)B of Hindu Marriage Act? It is also in negative, my lord. Is the petitioner wife entitled for the relief of restitution of conjugal? It is answered in affirmative, my lord. And is the respondent entitled for relief divorce to be granted under section 1? So answered in negative, my lord. What order means this petition is allowed. She wanted to join him, but all the members of the family, including husband, conspired together not to allow this way. So the purpose of marriage has been defeated.
looking at her status, my lord. Now she is in the state of vagrancy and destitution, my lord, for want of something, because parents are there in Madhuri, and she is in Ballad. They are not allowing her to settle down with either with the parents or with him. He is telling, I have resigned because of
Any other documents you want to rely on?
my lord. My lord, his own assets and liabilities, page number 40, my lord. A, personal information, 7.9. General monthly expenses of the applicant, 30,000 rupees. That is his expenditure, my lord. Next week, my lord. In the above case, honorable court ordered is 8,000 per month. Next, my lord, is dependent family members, parents. And then, my lord, F, my lord, details of income of the deponent, unemployed since 2 years. Everything is negative, my lord. And liabilities of the deponent, my lord. He has taken handover of 2 lakhs for medical expenses, 2 lakhs for other expenses. When he is unemployed, no fool will advance loan to him to the extent of 2 lakhs, other than if he invested in his own accounts in somebody's name. That's what. So this account totally created just to falsify the demand of that poor lady, my lord. That's my lord. In his cross-examination, my lord,
They're all in
page
Kannada.
number 68, my lord. Page number 68, my lord. ನೀವು ಹೊರದೇಶಕ್ಕೆ ಹೋದಾಗ ಮತ್ತು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವಾಗ ಅರ್ಜಿದಾರರ ಜೀವನಾಂಶ ಕುರಿತಂತೆ ಯಾವ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಹೇಗೆ ಮಾಡಿದ್ದೀರಿ ಅಂದರೆ ಮಾಸಂ ಪ್ರತಿ ಎವ್ರಿ ಮಂತ್ 6,000 rupees ಇಂದ 8,000 ನಮ್ಮ ತಾಯಿ ಮುಖ್ಯನ ಅರ್ಜಿದಾರರು ಪಡೆದಿರುತ್ತಾರೆ. Nothing in the law. Then
What is it?
Yes. When I was in abroad, I used to pay 6,000 to 8,000 to the wife through my mother. That's all.
Then my lord, when you are not
We'll
having,
continue tomorrow. List is smart list. Now what you have to do is all these matters. For example, list has stopped here. You should start from here. Then the remaining things come from bottom.
After the admission, it has to be.
So like it is from 87, it should come. Today, but now this will be. We'll hear it tomorrow again. So from there, the list will start. The passwords, whatever, like one password is there, that also should be on the top. But finalizing will come in their own place.
Yes.
Yes. Any mentions?
No, you lost my time. Not tomorrow.
You don't want it tomorrow?
No, you need tomorrow.
This matter on 13th.
1, please.
For further hearing.
Partner. Yes, next. 80?
87? इसके क्या है?
Let it come tomorrow. Tomorrow?
So tomorrow, next week,
Next week.
please,
List on 14th.
please.
Yes, sir. All these partnered matters will come on the top of the list tomorrow. Partnered will come on the top of the list tomorrow.
Interim order my conviction is not
In all these matters, in all these partnered matters, interim order is there till the next date, till tomorrow, till the next date of hearing.
92 months. 92 months. 92 morning they have taken time. That the interim order not extended.
92. It's already signed.
They have not informed me at all.
That's what we asked him. Like he said, somebody like.
Sometimes you also will say, wherever the interim order there, it will be extended. Under that guise you will learn. Sometimes you will not make mention of it.
No, it's happening. They're mentioning wherever it is. I mean, extending wherever it is. Yes. What will happen in the morning times when you make a mention? That time it will not happen. During while you are. Yes. No, all these partnered matters remaining will come tomorrow on the top of the list.
89, 89, my lord.
1 minute. 89, yes, tomorrow.
No, not tomorrow. 12th or 13th. 13th.
89 on, the other matter is coming up when yours.
13th.
13th.
Interim order my candidate.
Interim order earlier granted is extended. 90.
91, madam. So there are two writ petitions, one by the husband and another by the wife.
You don't want it to be heard tomorrow?
No, my submission is that settlement talks are going on. If your lordship directs, will keep the parties present. But this otherwise will refer to mediation.
90, 91 and 91.1 delete from part third. Both the parties were directed to appear before the mediation center on 14?
Yes, sir.
On 14.
Yes.
My lord, serial number 72, my lord, which is
Interim order earlier granted is extended.
serial number 72, my lord, which is adjourned to tomorrow for seeking instructions for withdrawal, my lord. Kindly 2 days time, my lord. I shall
72 lists this matter on 13.
Great.
Yes.
30.
Call each case so that there won't be any complaint. Monday, 90 on Monday, at the request of and calls for the petitioner, look at it, interim order is there, extend. Next. So all the finalizing matters, let it come to one. Serial number? 1 minute. 90? 13.
My lord, serial number
At the request
100,
of and calls for the petitioner, list this matter on 13th, yes.
100, my lord, Monday, my lord.
100 Monday.
Please.
97. 13th. Why everybody likes it on 13th? Yes. Any other matter? Yours will come tomorrow, or you also want adjournment? It will come tomorrow on the top of the list.
Awesome.
Other matters, let it continue. Signatures.